the appeals court, now sitting at Boston, within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning and welcome to the appeals court. I'm Judge Milkey. To my right is Judge Sachs. To my left is Judge Smyth. And together we are your panel for all 6 cases we're hearing today. I'd like to have a welcome especially to the first generation professionals group from Boston College Law School. Welcome. And now to the advocates. I'm sure you are aware that each side has 15 minutes of time. There is no opportunity for rebuttal. Since 15 minutes is generally not a great deal of time, we certainly would urge you to cut to the chase to the extent possible. We have read the briefs and the record, so we are familiar with the issues. At the same time, if you have completed what you want to say and there's still time on the clock, there is no shame in sitting down early. As one of my predecessors used to say, if you hit a home run, there's no reason to run the bases twice. And with that, I will call the first case of the day, Commonwealth versus Rodriguez, 2023 P778.
Good morning, Your Honors. May it please the Court. I'm Merritt Schnipper, appearing today on behalf of Jose Rodriguez. I'd like to begin, if I could, with the sufficiency of the evidence on threat and battery assault, because I think that issue should be dispositive of both the armed assault with intent to murder and assault with a dangerous weapon convictions. The evidence is undisputed that Brandon Daniels, the named victim, named alleged victim in these indictments, slept through the entire incident. There's no evidence he ever woke up during the entire incident. There's no evidence he ever perceived a threat to his safety from the gunshots that were fired. So this evidence is plainly insufficient for conviction of threat and battery assault under this court's decision in Commonwealth versus Chambers. And the Commonwealth functionally concedes otherwise. It has not disputed the sufficiency of the evidence on that theory. And instead, it's advanced what I would say is both a waived and unsupported argument that the court need not assess sufficiency under both instructed theories and only need to go forward under the attempted battery assault theory and assess sufficiency on that. Now, we do have an argument that the evidence was also insufficient on that theory for conviction, but I'd just like to focus briefly on the idea that the court is somehow relieved of the obligation to assess sufficiency under both theories. The case law doesn't support that. I mean, there's a reason that arguments set forth in a footnote to a brief are considered insufficient to rise to the level of appellate argument, and that's because they don't set forth the sufficient analysis to address a meaningful issue. I'd say that's particularly demonstrated here.
You seem to be forgetting the Commonwealth is the appellee, so they don't have to make an argument at all.
Well, that's right, but I mean, they have conceded the insufficiency of the evidence on this theory by not contesting it. I don't think there is any meaningful way.
Well, we'll be sure to ask them that when they...
Thank you. But so in any case, there certainly is no support for the idea that courts, when a jury is instructed on multiple theories of an offense and return a general verdict, no longer have to assess sufficiency of the evidence under each instructed theory.
There is evidence that the adult woke up because of the shots.
That's right, Jose
Why
Vargas.
isn't that enough to establish evidence of the threatened battery?
No, because there's, sorry?
Instant panic, he said. So he heard the shots and he felt...
And he kind of jumped up in the middle of the shot. So, I mean, first of all, I don't concede that that's sufficient for threatened battery as to him, because the question is the person has to perceive a direct threat to themselves, and what he says, there was 4 shots or 5 shots, he says, I jumped up when I heard shots ring out. That's all he says. He doesn't say, I was worried or I felt threatened. He just says, I woke up. But the issue here is that the jury is specifically instructed by Judge Mason, and this is because the Commonwealth chose to specifically indict with regard to a named alleged victim, Brandon Daniels, and proceeded on a transferred intent theory. So the jury is specifically instructed Brandon Daniels must have perceived a threat. Brandon Daniels must have been threatened with a battery. So,
so the judge did instruct on transferred intent. Can anything else be transferred?
right. So I've never heard of a situation in which transferred sort of awareness can be transferred. So in other words, I mean, in the Commonwealth versus Chambers case, that I'm relying on is really very instructive here, because there's multiple victims, or alleged victims in that case. This is a car driving towards another car on a street, and certain people see the car approaching them, and then before it hits them, two people in the back seat were asleep and only woke up upon impact.
There's no discussion of the issue there, of whether the perceived threat can be transferred to
No, I would just
else.
say this is exactly why briefing the issue from the Commonwealth side would have been useful. I mean, I never thought about transferring awareness.
It seems to me there are two different issues. One is, does the evidence need to be sufficient on both theories that were presented to the jury? That's what you said was in the footnote and has been waived.
Right.
But the theory about whether the other elements besides intent can be transferred is something else again.
It's completely novel, and I think, there's two ways to think about that, right? We have transferred intent. We don't have transferred perception or transferred harm. We have transferred intent, right? So that's the first thing. Just by its name, transferred intent is limited to questions of intent. And the second question then is, what do we do with the fact that jurors are specifically instructed that Brandon Daniels is the person who must have been aware?
But that's not a sufficiency issue, is it?
Well, we're looking at what could the jury have convicted on multiple theories, and can we be certain that whichever theory they might have convicted on, because the verdict was general, it's supported by sufficient evidence.
Well, I understand that argument, but the question is the sufficiency of the evidence, not something tied into the instructions. Why couldn't we conclude that the evidence was sufficient to convict on threatened battery?
Because to convict on threatened battery, a victim must be aware. They don't need to actually feel fear.
Well, I understand,
yes.
but the adult was aware.
I think the adult was very marginally aware. I think he was aware that shots, he woke up and he heard shots, right?
In a panic.
He did not use the word panic, I don't recall.
Instant panic.
Okay, he panicked. But you could panic when you hear an explosion from 2 blocks away, and that doesn't mean you're perceiving a direct threat to yourself. Right? I think the government needs to do a little more to prove its case.
You have a lot of issues.
I do, so it sounds like I should move on. Very briefly on the question of, unless there's a further question on this, very briefly on the question of attempted battery assault. I think the issue is, was it physically possible for the named victim to have been struck by this bullet, right? I mean,
why isn't that a jury question?
Well, I think we're phrasing it two different ways. I mean, it's not a jury question in terms of, there's a level, the government has to prove that it was reasonably close to
So I throw a knife at someone,
Right.
and as the knife is in the air, a truck drives in between me and the victim, blocks the knife.
That's a perfect counterfactual. So that's happenstance that prevents something that otherwise could.
So why isn't it happenstance? If the bullet had been an inch to the left, it might have missed the floor joist and gone right up through the sheetrock in the ceiling and the thin floor above and hit the victim.
Well, that would be a great thing to introduce evidence on when you have a burden to prove that something came reasonably close to accomplishing a battery. But all we have is a photograph of an indentation on the ceiling of a room below the room where a person was.
So how close is enough?
No, before we go there, we have some more, don't we? Don't we have the testimony of the ex-girlfriend that he admitted he was not only shooting, but shooting at different angles?
We have
Is
Ms.
confirmed by
Trento's
the bullet in
testimony
the
that he
ceiling?
shot at multiple angles, yes. So multiple, but the question here, and I'd like to contrast with the Commonwealth versus Melton case that the Commonwealth forwards for consideration. There's different types of impossibility, right? 4 victims there, 1 shot. It was not possible for the bullet to hit each person, but because each person was actually imperiled by the bullet, 4 charges of assault with a dangerous weapon could be advanced. The question here is, was the named victim actually imperiled by the shot? And I would just simply submit to the court when the evidence shows an impenetrable barrier that, again, is not something that's waving in the wind that could have been there or might not have been there at the given moment that a bullet travels, but was a permanent structure. It's simply not possible for a battery to have been accomplished. Thus, you could not have been reasonably close to accomplishing one.
You place a lot of reliance on the Horn case. Isn't the Horn case a completely different context in that it was about jury instructions? So
So
in that case, the facts were read in the light most favorable to the defendant. And the question was there enough on a reckless theory? Clearly, in this case, there is enough on a reckless theory, but that's not the question. The question is, was there enough with assault with intent to murder?
Sure. So with regard to the specific intent to kill required for the armed assault with intent to murder charge, and that's the case that that's the charge that the Horn case is so relevant to. So it's certainly true that arose out of instructional error. But the question there is what the SJC says when we have a situation firing through blinds that are closed with no indication that the rooms behind those blinds are occupied, and here, of course, they actually weren't occupied, and you say the name of the person you were arguing with before the shots rang out. So facts that are really difficult to distinguish here. That behavior can support a finding of recklessness for either third-pronged malice or involuntary manslaughter. Now, it's certainly true it arose an instructional error, but the question I think presented here is presented with a variety of, there's no doubt that if, the Commonwealth versus Henson case says is, if this type of conduct results in a death, it's not sufficient that it would have been justifiably convicted as a murder. It has to have been only on first-pronged malice. So the question in this case is, if this had resulted in a death, on what basis would the jurors have distinguished between the potential mental states in play, first-pronged malice, specific intent to kill on the one hand, and reckless disregard of conduct's third-pronged malice or involuntary manslaughter on the other? Is there any fact in this record that would have permitted the jury to differentiate between those mens reas such that we can say they would have been justified in convicting of specific intent to kill rather than reckless disregard of conduct, of consequences?
Two questions. First of all, your position is first-pronged malice is required.
Yes.
Is that right? Okay. Secondly, why can't the jury infer from the defendant saying, "Where's Quavo?" and then firing multiple shots at multiple angles into the house that he's trying to hit Quavo? He's not trying to just scare him.
Well, I'm there. So
Trying to kill him.
Well, my point is that given that what the SJC said under basically indistinguishable facts is that firing near but not at a person is reckless conduct,
Again, viewing the evidence in the light most favorable to the defendant for purposes of determining entitlement to an instruction. But here we're viewing the evidence in the light most favorable to the Commonwealth.
And I would argue that even in the light most favorable to the Commonwealth, a jury would have to speculate to select amongst those inferences. That's what I'm arguing. Not that it's an impossible inference to draw, but that it's no more supported than the recklessness that does not qualify for conviction of armed assault with intent to murder.
We're getting down on time.
Sure. Would the court prefer to hear about Guardado jury issues? I mean, I'm ready for everything.
I would go to the ID.
Okay. So I don't think there's any question that this in-court identification was improper. It certainly qualifies as equivocal. She said,
Now, the judge did not reach the good cause.
well, he didn't even reach Collins. He just said this issue has been adjudicated and decided by Judge Wilkins in the suppression decision.
I understand it's a little cryptic, but he seems to be saying that the first ID was sufficient. So once you allow the first ID, the first pretrial ID, then we don't need to worry about the 90%.
Well, I would respectfully disagree with that premise. I think that defense counsel says, Judge, under Collins, this is an equivocal ID, and what Judge Mason says is that issue was addressed and adjudicated by Judge Wilkins. We're not revisiting it. So he refuses to engage on the Collins question, which is whether something was unequivocal or not. The suppression issues,
or he concludes that Collins is satisfied by the initial pretrial.
I think you're being excessively generous there, frankly. I think it shows he did not exercise discretion when he had authority to do so, and he is not entitled to deference on this in-court identification. I just think it's clear that he refused to engage. He said this was decided by a suppression motion. The suppression motion was argued on due process and, Rule 403 balancing grounds.
So is whether an ID was unequivocal a question of law or discretion?
It seems to be a mixed question of law and fact that is basically committed to a judge's discretion, but the judge's discretion is only entitled to deference when it's actually exercised, and it's pretty clear from the way the judge gave this issue the back of his hand that discretion was not exercised. It was simply treated as not a relevant issue because it had already been decided in pretrial motion practice under a different legal standard. So I think that that was actually quite a prejudicial failure to exercise discretion, because assuming for purposes of my argument, if you will, for a moment, that the in-court identification is not admitted, at that point, the jurors are much more effectively invited to analyze whether this out-of-court identification should be trusted, because there's this, she hears a secondhand hearsay over the phone from Fargus that somebody named Joey Crack is the shooter. She goes on Facebook. She's searching for people with that name, so she's already beginning her search, you know, framed through a hearsay nickname that's associated with the alleged criminal events, completely separate from the Fielding case that the motion judge relied on, where, you know, there's a person sitting for half an hour in a hot tub with a guy, and the next day she provides a description of him, and an employee of the club pulls up his photograph based on the description.
I'm not sure why Facebook has, the context of Facebook has that much to do with the ID. She gets a name. She goes looking for people with that name. And he could be there or he could not be. She looks at the photographs, she sees one, and she says that's him.
Sure, but she could also be sorting through a set of photographs that she comes into them with a preconceived idea that these are people who have the name of the shooter, right? So she's not beginning, so to begin with a name.
But why is that different than people who live in the neighborhood or people who hang around a particular bar? Or, I mean, you know, the person might be in that group. She takes a look. She doesn't know if she's going to find anyone or not. She finds someone.
Right, but the use of a nickname that's already associated with the event is something that predisposes a person to make an identification. This is exactly why identification procedures begin with descriptions of suspects and are based on neutral categories and not
Except here, there was no government involvement at that stage.
Oh, right. And I'm not saying that the out-of-court identification, again, I do think the out-of-court identification was unreliable, but I'm not really focusing primarily on that aspect. I'm saying it was the prevention. The in-court identification prevented the jurors from fairly assessing the very questionable circumstances that produced the initial identification of Mr. Rodriguez, which is the only identification by an eyewitness of him. I mean, we do have Ms. Trento's testimony, but I think she's pretty fairly impeached by virtue of her, 4 years later coming forward after she loses a child support order to say all sorts of terrible things about Mr. Rodriguez.
But again, wasn't that for the jury to sort out?
Yes, without having it all papered over by a bad in-court identification, where the witness can then, with puffed up certainty based on the fact that she's participating in the overall prosecution, saying, yes, that's the man who I saw shooting, when in fact, looking at the overall circumstances of the case, the ID is far more ambiguous.
May I ask one more question about the ID? Does the Collins formulation has in it that unless there was a non-suggestive, unequivocal out-of-court ID?
Correct.
Okay. So does the due majority take that non-suggestive requirement out of the analysis, especially when contrasted with the Chief Justice Ganson? But
so in due, that was based on a show-up, right? So they said we are going to paper over. We're not going to say that a show-up cannot, as a matter of law, produce an in-court as long as the show-up itself is clear and free from doubt, right? So that is true, that's what they said there, but they were contrasting show-ups there with police-administered procedures, which is what Collins is about. So in Collins, so if the question, as I understand it, is whether because a show-up could permit an in-court ID under due, thus there are sort of the independent social media search can produce it under, is that the question?
I'm going to have to think about whether, I'm not sure.
So I think I guess what I would really say is, a show-up is a police-administered procedure immediately after a crime, and it's supported by good reason, immediacy, and all the rest. Here we're talking about 2 weeks later, overheard hearsay in a phone conversation, going to Facebook to find a nickname. So I think it's significantly more suggestive than a show-up in the immediate aftermath of the crime, I suppose we might answer there.
Counsel, I'm afraid we're going to have to leave it there.
I appreciate it. I ask that you reverse Mr. Rodriguez's convictions. Thank you.
Thank you very much. We'll hear from the Commonwealth.
Good morning. May it please the Court. Assistant District Attorney John Wendell for the Commonwealth. Since the Court was just discussing it, I'd actually like to start with the identification, the Collins issue. I would respectfully suggest that Collins doesn't actually apply to this case unless it is as modified by due. This is Collins, that's 470 Mass. This is at pages 261 to 262. begins by quoting Creighton. Where an eyewitness has not participated before trial in an identification procedure, we shall treat the in-court identification as an in-court show-up and shall admit it in evidence only where there is good reason for its admission. They then further quote Creighton, and then, we consider here whether to adopt that rule, it becomes an in-court show-up rule, where the eyewitness did participate before trial in a non-suggestive identification procedure and made something less than an unequivocal positive identification of the defendant. Footnote 8. We do not address the admissibility of an in-court identification where there has been a suggestive pretrial identification procedure. Collins doesn't apply on its own terms to a suggestive, unequivocal out-of-court identification. So you have to import do where a suggestive but unequivocal identification is permissible, and that's fine under Creighton.
Doesn't the suggestiveness make it worse, not better?
But that goes back to do, that, again, the identification must absolutely be unequivocal in either case.
And
so
help me to understand why, at least if you focus on the second pretrial identification, where she said 90%.
Right.
Why isn't that equivocal? And
I would,
in the words of the SJC.
I would suggest that in the particular context there, when she says 90%, I mean, the photographs are in the appendix. I forget the specific pages. In the particular context where she says, oh, it was 90% because his hair was a little bit different and he wasn't wearing a hat in the mugshot, she's effectively saying that she's 100% certain that the guy in the mugshot bears a 90% resemblance to the guy she positively, unequivocally identified prior to that in the Facebook photograph. So it's a 100% certainty of a 90% similarity in appearance. And the photographs are different. As I say, they're in the appendix. They are obviously different photographs. But regardless, we have an unequivocal identification, an unequivocal pretrial identification, which is the good reason to permit the in-court identification, even if that later identification is no good. And the defendant didn't attempt to show that there was no good reason. It is the defendant's burden to establish that there is no good reason. There was simply a statement, Judge, I want this identification out because Collins. No particular explanation, no discussion of, oh, there's no good reason. And when the judge says, well, that's already handled by the motion to suppress, the motion judge actually found that the identification, the pretrial Facebook identification, was not suggestive. I don't know that either party actually agrees with that, but so he found on that finding it is a non-suggestive, unequivocal identification, and the witness is therefore permitted to make the in-court ID. So I don't think Collins actually prevents that Facebook identification from being the unequivocal pretrial identification, especially where do follows up and says, yeah, show up is fine so long as it's unequivocal, because show up identifications are suggestive. By definition, show up identifications are always suggestive. But we permit those out-of-court suggestive identifications to be the basis for an in-court.
Why isn't the introduction of the hearsay regarding the name in some respects inherently prejudicial?
Which hearsay? You mean the
fact that she searched for this name because somebody was telling the other individual about that this is the guy by this name who did it.
Right. That's why the Commonwealth would agree that the Facebook identification is suggestive. There is some suggestiveness there in that someone told her, this is the guy who did it.
But it's not just, I'm not even focusing on the suggestiveness here so much as the jury effectively hearing that there's some chatter out there confirming that someone by this name was the shooter.
I would suggest it wasn't admitted for its truth. It was admitted for state of mind purpose. her explanation of why she's going looking at photographs of Joey Crack, the police investigation, why they are looking into this person known by this nickname, why they put these photos in front of her for this identification procedure. It's not actually admitted for the truth of Joey Crack being involved in the shooting.
There wasn't any evidence that this defendant was known as Joey Crack, was there? Other than the link through the photograph?
Aside from she looked at Facebook photographs with Facebook
Through the
profiles.
photograph. Right.
Aside from that, nothing.
But the victim,
I thought the girlfriend, the ex-girlfriend,
I apologize. You might be right. It's been a while since I've read her testimony. In any case, if there are no further questions on the identification, I'd like to move on to the assault issue. So starting with the question of the different theories, there's a rule, a corollary to the rule, and a separate rule that are in play here. The rule is where there are separate theories, the evidence must be sufficient as to all theories.
Luckett's rule?
Yes. The corollary is where there are separate theories, the jury should be given a special verdict form and state with specific unanimity what theory they're convicting under. So that's in first-degree murder, for example. Deliberate premeditation is a theory, extreme atrocity or cruelty is a theory, and felony murder is a theory. The jury must be unanimous as to which theory of first-degree murder they're going under. Then there's the other rule, which is the rule that is stated in RYNE, which is that threatened battery and attempted battery are not actually separate theories of assault. That term theories has been used, but within the meaning of the Watkins rule and the Watkins corollary, they are not actually separate theories. So the jury does not need to be specifically unanimous, and as stated by Andrade, the evidence we don't even need to look at the sufficiency of the evidence for the one charge, for the one theory that isn't actually a theory, if there's evidence under the other not theory. So the language used by the courts has been confusing, which explains where Chambers comes from, but...
How do you address the fact that Porro actually cites Chambers?
Porro does not cite Chambers. It addresses the topic. There are no...
It does cite Chambers.
Does it?
In terms of what each theory entails.
Oh, there it is. Courts have assumed without deciding that both forms of assault were lesser. Includes that is the only citation to Chambers. That is not this framework in Chambers. It's the general idea that both ideas of assault are, that is the only citation. No published case cites to Chambers for the proposition that both theories of assault must be proved or must have sufficient evidence in order.
Is the Commonwealth conceding that there is insufficient evidence on the threatened battery?
I don't know that I would go that far. We get to the question raised by the court to Attorney Schnipper about whether transferred awareness is a thing. I'm not sure the law is clearly developed on that subject. I didn't go into that. And assuming that it isn't a thing, I would be forced to concede there's no evidence of the named victim's awareness. Assuming transferred awareness is a thing, the evidence is sufficient under that idea.
Was the victim named in the indictment?
Yes.
Or just the jury instructions?
Named in the indictment.
Okay.
This was a clear transferred intent case, which, with that in mind, I will move on to the question of intent to murder and what precisely we do with Horn. As the court was pointing out, Horn is a jury instruction case. The evidence there is reviewed in the light most favorable to the defendant. And the discussion in Horn, the defendant in Horn was convicted only of second-degree murder. And under second-degree murder, third-prong malice is on the table. And the issue in Horn is that third-prong malice is so closely related to recklessness that there is a view of the evidence in which it could just be manslaughter. But that's the view, that is the evidence in the light most favorable to the defendant. Horn doesn't actually say that the evidence was insufficient under first-prong malice, does not say that the evidence was insufficient as a matter of law to prove specific intent to kill. What it says is that in the light most favorable to the defendant, it could also just be recklessness.
So you agree that first-prong malice is required?
Yes. First-prong malice is required because it must be a specific intent to kill, and that is first-prong malice. I would suggest there's a
Specific intent to kill or specific intent to murder?
specific intent to kill, not mitigated. That's Johnston and a few other cases. If there is intent to kill and there is no mitigation, such as provocation, heat of passion, something like that, then the intent to kill is effectively evidence of intent to murder. So here there's no evidence of any kind of provocation or any other mitigating circumstances. So if there is evidence of intent to kill, then there is evidence of intent to murder.
What is the strongest evidence that the defendant knew Fargus was in the house?
Well, so there's actually, during Felicia's testimony, she says that he was there a few minutes before, he was there to pick someone up. On redirect examination, she's asked, so you testified on cross-examination that it was about half an hour before? But as far as I could tell from a review of the record, that's the only reference to this being half an hour prior. The defendant is in the light most favorable to the Commonwealth. He is there shortly before the end of the night. This incident with Fargus goes on for a while. He's there to pick another individual up as the party is breaking up. And
What does she say on redirect?
She agreed on redirect that she had testified that it had been about a half an hour, but it's not, there's no actual testimony from her that, oh, it was about half an hour prior. Besides, that's half an hour prior to the shooting, which the shooting takes place some minutes after the last of the guests leave, where the guests begin to trickle.
5 minutes, I thought, was the testimony.
5 minutes after the last of the guests leave, whereas the guests begin to trickle out after this rant. So he could be there half an hour prior and still be entirely aware of where Fargus is. In any case, he asks where Quavo is. It's apparent that he is a friend of Fargus. He knows Fargus. He apparently knows he stays there, has been there all day. So then he asks, where's Quavo? And then he fires in what I would suggest is a saturation pattern into the house. Multiple shots, multiple angles at an upward trajectory. It is something of a miracle that the bullet did not enter the second floor, did not strike the named victim.
Could we, in the little time we have left, could we turn to the Guardado issue?
Yes.
Tell me if I'm wrong. The only evidence of licensure was the statement by the officer that there was no evidence of an FID card on file.
That's correct.
Now, strictly speaking, the firearm charge was a Section 10A charge.
Yes, Your Honor.
So he needed a license, not an FID card, right?
Yes, Your Honor. I would suggest two things. First of all, in the context of the question as asked, I would suggest that the answer, there's no FID card, implies, or any other evidence of licensure. The other thing is...
No, but that may be true, but the standard is harmless beyond a reasonable doubt.
Yes. The other point, which I think is rather more interesting here, it's not possible as a matter of law to have a license to carry without also having an FID. So as a matter of law, if he has no FID, he has no license to carry.
And how do we know that proposition?
That's within the statutory scheme, Your Honor. And that's, had the jury been properly instructed, they could have been instructed, the defendant, you must find that the defendant did not have a license to carry. I instruct you as a matter of law that if a defendant does not have a firearm identification card, he also does not have a license to carry.
And do you agree with the statement in the reply brief that there was no evidence regarding the ammunition?
I disagree with that. The evidence for lack of license for the ammunition, lack of license, is the lack of an FID card. The FID card is the license
Even though
necessary.
the jury was not told what an FID card was or what it meant?
Correct.
Or
Because
whether it was required?
Had they been properly instructed, they would have been instructed to find the defendant guilty of this 10H charge. You must find that he possessed an item, that the item was ammunition, and that he did not have a firearm identification card or other licensure to possess this ammunition. So the jury, if properly instructed, would have been told that an FID card is the license necessary to possess ammunition.
So 140-129C provides for a FID card or other kinds of exemptions.
True.
And otherwise being an exempt person under this section. Does the Commonwealth have to disprove that?
What context, Your Honor?
In this context? Is
you mean
evidence that he doesn't have an FID card sufficient to prove that it's unlawful? How do we know he isn't a firearms dealer, or I don't know who all the, member of the National Guard or whoever the exempt people are under 129C?
Sorry, I meant, do you mean as to the ammunition, or do you mean
ammunition? Well, actually both, but start with ammunition.
I honestly hadn't considered that question. I'm not sure I'm prepared to answer it right now. I may look into that and file a 16L letter.
Only if we request it. We're going to have to leave it there. Thank you very much. Excellent arguments by both sides, and the case is submitted.
Thank you.
Our next case is Commonwealth versus, actually I have the name on here, but given that this is a juvenile, I'm not going to say the name. 2023 P548.
Good morning, Your Honors. May it please the Court. My name is Jalinpan Nakam. I represent the juvenile appellant.
Could you move the mic just slightly? Perfect.
Yes. Okay. I'll speak up. The exit order and pat frisk here were not justified. I'll start with the Court's reliance first on the driver. The trooper's observation of the driver and her conduct was wholly unrelated to what was happening in the back seat. My client was a passenger in the rear front passenger area. When the trooper stopped the car and approached, his initial attention was drawn to the driver. He told her, "Stop reaching." He told her again, "Stop reaching."
Or stop moving.
Stop moving. And the front passenger side occupant was heard saying, "Well, she's reaching for her shoes." And understand that the judge credited that testimony, trooper's testimony, as corroborative of the driver reaching. He leaves then the side where he was standing at that time that he left to go approach the driver's side. The second officer, local police officer Touchette, was already present, standing by the sidewalk. He approached the driver, had her exit the car, handcuffed her, placed them in his cruiser, and then retrieved what he later discovered to be a backpack.
What I read the motion judge to conclude was that the police could reasonably have suspected the driver was creating a diversion.
Your Honor, I think...
So yes, she was, the threat that she posed once she was cuffed and in the back of the cruiser is one thing, but whether she was creating a diversion could still lend to reasonable suspicion.
Well, I don't want to confound two sets of individuals that the court credited the trooper's testimony with respect to creating a diversion. With respect to the driver, I think that the issue was much more narrow than that, which was that it morphed the civil infraction stop into something more. So to the extent that the court found that the driver's conduct contributed to suspicion of creating a diversion as to what was happening elsewhere, there's no evidence at that time that the trooper suspected something else was abound, other than suspicion specific to the driver's conduct. So when he went to remove her from the car, handcuffed her, if there were any concerns with respect to safety, certainly that was dispelled because she had been secured, handcuffed, and placed in a cruiser. She had told him that she had marijuana in her backpack.
Well,
and
the trooper might not have testified to it, might not have thought it subjectively, but the judge, in his findings and conclusions, said the driver had already been removed from the vehicle due to repeatedly reaching despite being instructed to remain still, which could also support a conclusion that there was an effort to create a diversion for the police, citing a federal case, a First Circuit case. So, you know, what the trooper thought subjectively is one thing. Could the trooper reasonably have considered, or the judge reasonably have considered that added to reasonable suspicion?
Well, I think maybe the trial court at that considering that may have been a subjective component of the trooper. That did not come out. I don't think the transcripts show that. I don't think that that's clear in the video
No, that's
camera.
what I'm saying. Even if it doesn't come out in the transcript that the trooper thought the driver was creating a diversion, the subjective impressions of the officers aren't controlling. It's what they could objectively conclude. Are you saying that it's not possible to objectively conclude that the driver was creating a diversion?
Correct. The trooper specifically addressed the juvenile's conduct, at no time related it back to any concerns he had with respect to conduct of the other occupants in the vehicle. So my point is, when he did, if he was concerned about her conduct, removed her from the vehicle, searched her backpack, found that she had marijuana and no other items that could constitute contraband or supported any concerns he had, that was dispelled. The investigation into her conduct at that point was concluded. It had no connection whatsoever with behavior or conduct that he could have attributed or imputed to the
The safety
other
threat that she herself posed, I would probably agree with you, had ended once she was cuffed and in the cruiser. But that doesn't dispose of the question whether she was creating a diversion.
It does, Your Honor, because the testimony did not at all even insinuate that her behavior was intended to divert the trooper's attention. I think you can reasonably infer that she was afraid because she had marijuana in her bag and that she was not licensed to drive, and there was not a properly licensed driver because she only had a permit. There was a licensed driver, but she, I believe, was not at the age where she could accompany somebody who only had a permit. So I think that's just as reasonable an inference from where there was lacking testimony from the troopers specifically saying.
Might be just as reasonable, but the officer doesn't have to eliminate all possible innocent explanations.
I'm sorry, Your Honor?
That might be a reasonable inference about why the driver was nervous, but the Commonwealth doesn't have to exclude all possible reasonable explanations for a person's behavior.
I would agree with that, except that I think it would be quite attenuated to suggest in this case that after the police officer observed the juvenile's conduct, left, if there was any other concern, it certainly did not, was not critical to him staying and conducting further investigation into the other occupants' behavior. He left them there and went to approach the driver. And when the driver was taken out from the vehicle, he cuffed her and searched the backpack, corroborating actually what the driver said, which I would submit is more of a reasonable inference, again, that she was trying to hide the fact that she had marijuana in her backpack. So I think that the reliance on that as a component and a factor to determine whether or not it was proper to then have the juvenile, my client, removed from the vehicle, I think is separate and distinct. Those two conduct were not at all connected. Taking that aside, additional factors that the trial court relied on, the idea of the juvenile wearing a crossbody bag, the juvenile pinning. I would address first pinning. I could not find any case law
Is
regarding
pinning the new blading?
the case law I found was all blading. So I would say this, the two types of behavior, based on what we learned from Trooper Smyth, are entirely distinct. Blading suggests a combative stance. Blading suggests
There was no claim of blading here, right?
There was no claim of blading.
Okay.
Pinning, which we had a difficult time understanding. I had a difficult time understanding what the trooper actually was trying to testify as to what that meant. What I understood it to mean was after he explained and elaborated that in his prior experience, he had observed pinning. And in those instances, he said pinning occurred when the suspects that he had previously observed were in motion. They were walking, they were running, and one or more of their limbs was not moving, suggesting an unnatural movement, which may raise suspicion. Here, pinning is not necessarily applicable. Juvenile sat in the back with the crossbody, and his hands were on his lap. I understand that the trooper assigned that his sighing or exasperated sigh it meant something. I suggest it was just exasperated. He was late for a curfew. There are other inferences that can be drawn from
Was the judge clearly erroneous in concluding that the trooper could reasonably think that Juvenile was trying to hide the pouch portion of the bag?
Through the action called pinning, yes.
Well, what about the fact that when he gets out of the car, the bag part is really on his back, on his left back?
I don't know if that's how the evidence materialized, Your Honor.
Well, you can see it from the video that that's where the bag is.
The incident, the time from the juvenile being removed from the vehicle to the time of the pat happened almost concurrently. There was nothing objectively different from the facts that the basis that the trooper used to remove the juvenile from the vehicle. So, and he did not testify to that. He removed the juvenile from the vehicle and immediately patted him down, where he found, obviously, the gun. So the issue then goes back to, did the trooper have sufficient factors to justify the removal of this juvenile? And we're back again to this pinning and the crossbody. There was a lot of evidence that came out regarding the crossbody, which is, the trooper says, based on his training and experience, he cited to a number of prior investigations he had been involved in, specifically, that involved individuals who wore crossbody bags, and he testified that these crossbody bags in those instances were used to hide contraband. Crossbody bag came out in evidence, widely used, quite common, and there was nothing unique about the features that lent the body bag to being suspicious. The juvenile wore it in the way that it was intended to be worn, which is across his body, and at the time that he was seated, it was visible. And that was also visible in viewing the trooper's body cam. So there was nothing more offered other than the trooper's training and experience. And I drew a distinction between what training and experience meant.
So the judge finds, apparently crediting Trooper Smyth, he has on-the-job experience with approximately 5 crossbody bags containing firearms during his time on the narcotics unit of the New Bedford Police Department. I don't see you arguing that that's clearly erroneous, do you?
I do, because the crossbody bag does not inherently have suspicious factors.
I'm asking a narrower question. This is the equivalent of a finding that Trooper Smyth had experience with 5 crossbody bags containing firearms during his time on the narcotics unit. Is that finding clearly erroneous?
Yes, it is. That is assigning characteristics to that crossbody bag.
No, I'm just talking about his experience, not what inferences could be drawn from it. That's a separate question.
He's talking about the subsidiary facts.
I'm sorry that if I'm not clearly understanding the question. So if I can make a distinction then between training and experience, the cases that I cited, I think it was Garner, The officer there was credited with training because he specifically, and I think that was a blading case, and that he observed conduct of the suspect's movement, clutching, waistband, and of that nature, that he received specific training by the ATF. Here, there was no training at all, and I think that was
That's what the
conceded.
judge found.
But I think
Judge
training...
found trooper didn't have any formal training on the use of cross-body bags being used to hold firearms.
Aren't you actually making a different argument, that there's a logical fallacy here, that the number of times the trooper found a gun in a cross-body bag is actually beside the point, because we don't know how many cross-body bags he observed. I mean, it may be that, for example, people who have guns carry them in cross-body bags, or for that matter, purses, but it doesn't mean that anyone carrying a purse or a cross-body bag therefore is likely to have a gun inside.
I think that's much more artfully phrased than what I was trying to accomplish. And as a matter of fact, I was going to offer an example of myself walking around with a purse, and which is quite ubiquitous. If the trooper had been involved in prior investigations involving a purse where he was able to confiscate contraband, then does the fact of my carrying a purse make me suspicious or
Well,
ask
probably not, but if someone checked your license plate and found that you had an open charge for assault and battery with a firearm, wouldn't that, together with the purse, at least heighten the suspicion?
Well, I think that the crux of the exit order here rested on that finding of the open charge. Under Cordero, having an open offense, or even a conviction for that matter, alone is not enough.
Well, we're not talking
to
about
justify.
alone. We're talking about with the crossbody bag and with some of the other, the pinning and the pedestrians creating a diversion and the other things the judge relied on.
Well, that's assuming that those factors were themselves quite credible. I cited to a case that states just because there's piling on of innocuous or innocent
Right,
facts
8
doesn't amount
zeros.
to anything. But here, assuming that those factors are mitigated, and the fact is, if the officer was that concerned regarding about his safety, or that he suspected that the juvenile was armed and dangerous, he would have done it already. It was the finding of the open charge that I think made the difference in his decision to have the juvenile removed from the vehicle. Cordero says that that's not sufficient. And I cited to Torres, Garner, and Sweeting Bailey, where the context here matters. In Garner, the police officer had prior dealings with that suspect, and he remembered that that suspect was cooperative and provided him with information, was compliant, and found that to be true in the underlying arrest as well. In Sweeting, however, the police officer had familiarity with that suspect, but at the time of the underlying, I see that my time is up. I'm happy to stop or finish my thought.
No, you can finish the thought, and then I think we have some more questions.
In Sweeting, we have an officer who was familiar with the suspect and previously recalled that that suspect was compliant, was cooperative, but at this underlying new offense was combative, was unusual, exhibited strange and odd behavior not consistent with what the officer remembered. So those factors mattered, and in this particular case, none of those things were apparent. Certainly, there was no conviction. At minimum, in Garner, there was a prior conviction. The trooper had no additional information as to the facts and circumstances surrounding the open offenses. I'm sorry, Your Honor.
No, we've read Garner. Thank you, though. But my question refers to the standard of review. And we're highly deferential to findings of facts of the motion judge, correct?
Yes.
And the motion judge credited testimony that the juvenile was moving in a certain way, pinning or shielding or doing something that caused suspicion, correct?
Yes.
But in this time or in this era of body cams, we also have videotape evidence.
Yes.
And as a reviewing court, it has been held, we review video evidence de novo. Do you agree with that?
Yes.
So if we reviewed the video and saw it differently than the trial court, how do we reconcile that as a finding of fact?
Well, I think this court could consider that as to whether or not the motion judge's findings are sufficient to warrant the denial of the motion. The video speaks for itself. I mean, it's to the extent that there are certain things, certainly that are not viewable. For instance, the angle with which the trooper stood where the juvenile sat, it may not be visible that what he termed pinning was happening, because that is just simply not visible. Certainly, I viewed it. I do not believe that I saw it, and I viewed it many times. With respect to the two females who approached Touchette as she was standing on the sidewalk observing the juveniles while the trooper was running record checks, for example. That's not necessarily visible either. But to the extent that the video was visible, it did not show that there was any disruption in the investigation whatsoever. So if there are no other questions.
Just one.
Yes.
The trooper did not say that the exit order was issued because he suspected a crime was being committed. And in fact, he sort of disclaimed that on cross-examination.
That's correct. He conceded that.
And the judge didn't rely on it. But if there was reasonable suspicion that the juvenile had a firearm, would that in and of itself be reasonable suspicion that a crime was being committed?
Okay.
I mean, a juvenile can't possess a firearm particularly.
Correct. I mean, we're assuming at this point that the trooper was aware of the occupant's age at this point. If he's returning because he's already...
Well, he found a open juvenile court record, so I think that's pretty good reasonable suspicion.
So if after the trooper found the open charge, knows that the occupant...
My basic question is, can a juvenile lawfully possess a firearm in a car?
No.
Okay. Thanks.
Thank you, Your Honors.
Thank you very much. We'll hear from the Commonwealth.
Good morning, Your Honors. Stacey Gauthier for the Commonwealth. It's the Commonwealth's position that the motion to suppress was properly denied by the judge. It's our position that the stop, the pat frisk, and the exit order were all proper.
Can we start there? You say in your brief, well, the judge didn't find it was a traffic stop, but of course it was. How? Why? Isn't the violation of the inspection sticker law on the owner of the car, at least in this context? Is there anything illegal about driving a car that doesn't have a proper inspection sticker?
Well, I believe that the testimony was that that was a citable offense. So certainly he could, I mean, you have to have an inspection sticker.
But citable to whom?
I would suggest the driver or the owner, but he doesn't know as when he pulls the car over whether the driver is just the driver or whether the driver is the owner.
Aware from his computer is, frankly, gratuitous computer search of the car, he learns that it wasn't properly inspected. Why can't he tell motor vehicles to issue a notice of violation to, why is there any reason to stop the vehicle?
Because he doesn't know who's driving. And if it's not...
But how does it fall on the driver? Tell me what the regulation is that says you can't drive a car without a vehicle, without a inspection sticker.
I don't, off the top of my head, have the citation, the legal citation to that. I'm happy to, if the court asks, to do a 16L and to get that information. But, excuse me, otherwise, he stopped the motor vehicle for the inspection, and then once he gets to the passenger side, he sees that there's 4 occupants in the car, none of which are wearing a seatbelt. So now I would suggest that under Commonwealth versus Buckley, because he makes that observation, he can now expand the scope of the stop, because now he's got 4 people that he might write a citation to for not wearing seatbelts. So at that point, he can collect everybody's biographical information and he can run it.
And all 4 individuals were cooperative.
That is correct, Your Honor. However, as he's taking the information, he's making observations, one of which is the driver of the seat keeps reaching under the seat, and he can't see what she's reaching for. And he tells her at least twice at this point, stop reaching. And if you watch the video, he even tells her, stop reaching, you're making me nervous.
And he gets her out of the car
and she continues.
Handcuffs her.
Yes, yep, and then he puts her in the back of his cruiser, and then he sits in his cruiser, and he starts running the biographical information. However, if I may just go back, prior to him pulling her out of the car, he's standing there speaking to the occupants, and he's making other observations, and he's observing the juvenile, the back passenger. He's making motions, he's like sighing and running his hands through his hair. And then he has this cross-body bag, which the trooper testified he had on-the-job training and experience, are often cross-body bags oftentimes used to carry guns. And so as he's still talking to the occupants, he's noticing what he believes the juvenile has the pouch of the cross-body bag, and he's what the trooper calls pinning, and he's moving it to to his side, his left side, when the officer is on his right side, so the officer can't see the pouch.
There's something in the record about arms down along the side, not moving.
Yes, which he called...
So the driver's making him nervous because she's moving.
Yes.
And the kid in the back seat is making him nervous because he's not moving.
That's correct. And I'd also point out that there's 4 occupants and there's 2 police officers, so they're outnumbered.
You make it sound like it's chaos, that, they're surrounded by 4 people. They're in the car.
They're in the car.
You got 4 kids
correct.
in a car and 2 heavily armed police officers outside the car. Is this really an inherently dangerous situation?
Well, I would suggest the officer doesn't know. At this point, right, because we got somebody moving, he doesn't know what she's reaching for, and then we have the juvenile in the back who's got a pouch that is sometimes used to carry guns, and he's pinning. And when the trooper spoke with the juvenile said, I've got to hurry up and get home. I have a 6 o'clock GPS curfew. And it was about 20 minutes of 6, and the officer asked him where he lived, and where he lived was in the opposite direction of where the car was traveling. So now we have the officer making an observation that the juvenile is telling him he needs to be home, but he's going in the opposite direction. So that's just adding to the officer's reasonable suspicion that there's something else going on here. So he does eventually, he does get the driver out of the car. He handcuffs her, puts her in the back of his cruiser. Then he gets into his cruiser and starts running the biographical data of the occupants of the car. And so then he runs the juvenile's biographical data and sees that he's got an open firearms charge out of New Bedford Juvenile Court, which included the use of a firearm. And so at that point, I would suggest that would, tip the scales. And even more, as he's running everybody's biographical information, there was another officer outside the car keeping an eye on the other 4, and 2 people walked up on the street and started what that officer thought was trying to distract her from keeping an eye on the 4 people in the motor vehicle. So now we've got 6 people, we've got 2 outside, 4 in the car, and 2 officers.
We've seen the video.
Okay, and thank you.
Not much of a distraction.
Well, it was a distraction enough so that Officer Troussette, the officer who was out on the street, she called for backup. And I would also suggest that it's clear from the body cam video that we can't see what's going on with those people when they first walk up, because it's Officer or Trooper Smith's body cam, it's on his chest, and all it shows at first when he's in the car is the steering wheel. So we don't know what's going on out on the street. All we know is that when he starts getting out of the car, there's these other 2 women here, and Officer Troussette is yelling at them, and then Trooper Smith also has to tell them to move away. And
state in the most succinct way you can, what was the basis for the exit order of the defendant?
It was a combination, it's a totality of the circumstances, so it was a combination of everything. It was the fact that the driver kept bending down and was reaching and was not listening to the officer's instructions. And under Commonwealth versus Sweeting-Bailey, we can look at, we can put the co-people in the car, like their behavior can go towards the reasonable suspicion analysis. We've got that. We've got the juvenile telling the officers that I have to be home in 15 minutes, and his house is in the opposite direction of where the car is heading. We have his behavior, that he was, shuffling around in the back seat. He's got,
He was staying still.
well, he was putting his hands in through his hair.
Very
He was-
suspicious, wouldn't you say?
Yes. That's what, the officer felt that it was suspicious when you put that with the driver, who was also shuffling under the seat. And he's got the crossbody bag, that the officer, through his on-the-job training and experience, he knows people to carry firearms in that. And the juvenile is pinning that, right? He's taking it and he's moving it to the side where the officer can't see. And if you, excuse me, if you watch the video, and I believe Justice Sachs already pointed out that when he gets out of the car, you can see that the bag is a little bit in the back, and the trooper actually takes it and moves it over to the side. So we have that. And then we have the stiff, when he was sitting in the car, when he did put his hands down out of his hair, it was stiff down at his side, again, with that pouch there, trying to keep that pouch out of the officer's view. We then have the fact that he has an open firearms charge out of New Bedford Juvenile Court, which we can consider that into consideration. That's Commonwealth versus Garner. And also, then we have the two females who come up and are, what the officers feel, trying to cause a distraction to her while she's watching the other four. So I would suggest that, looking at the totality of the circumstances, I would suggest that that is enough, that is reasonable suspicion, that there was a threat to safety to get him out of the car, and that also I would suggest that that was specific and articulable facts to show that he was armed and dangerous for the pat frisk. And then the trooper, you can see him on the video, he manipulates the bag, and he feels that it's, like a metal heavy thing that he thought was consistent with a gun, and he can open up the bag under the Plainfield Doctrine, under Commonwealth versus Amato. So I would suggest...
How do you address the fact that in the middle of this, the trooper says to the defendant, "I'll get you out of here in a second," or words to that effect?
Because at that point, I imagine that he thought he was going to get him out, right? I mean, he didn't know what was going to happen, what was going to unravel over the course of the stop. So I would suggest, at that point, he wasn't the driver.
That's right.
And if there's any further questions, I'll rest on my brief.
What's your strongest argument for counting the conduct of the driver once the driver was secured in the back of the cruiser?
Well, I think that once she's secured, I don't think you can count her. I don't think you can count her behavior anymore. Once she's handcuffed and she's in the car, but once she was handcuffed and in the car, there was other factors that the officer was taking into consideration, which was the fact that the juvenile had an open criminal case involving the use of a firearm.
So the
And
judge,
the other two people, I think that's when the other two people walked on the scene.
well, the judge cites that First Circuit case and says that the conduct of the driver could be viewed as trying to create a diversion. And do you agree with that, disagree with that?
I mean, I think
she would no longer be creating the diversion once she was in the back of the cruiser, but the fact that she had been trying to create one,
I think
does that legitimately add to suspicion?
I think that does. The fact that she, when she was loose in the car and unhandcuffed and was reaching down, I think you can look at it all.
Why would that be at all a rational thing to do? I'm going to create a diversion by scaring the cop.
I don't know, but he kept telling her that she was making him nervous.
No,
and
I
she kept
understand.
reaching,
And
so-
I got no problem with the cop taking the driver out of the car. But as a diversion, I mean,
Well,
the
he's
trooper
got the
never...
gun, she's got the marijuana, right? Like, what's worse, right? The gun, right? So why not take the
There's
hit?
no
Why not take the
knowledge-
hit for the marijuana?
There's no knowledge that the driver or any of the other passengers had any knowledge of the gun, correct?
That is correct. But, well, I mean, wait, I'm sorry, I'm just going to take that back. They told the police that they had no knowledge of the gun. I don't know, we don't know. They told the police they didn't know about the gun.
I'm still trying to figure out how it makes any rational sense as a diversion to keep reaching under the seat.
I mean, he kept telling her to stop, and she wasn't stopping, so that raised his suspicion. So whether you take that as being a diversion, or whether you just take that as a factor that you can consider in the reasonable suspicion analysis, that it made the officer nervous, and it made him believe there was a threat to his safety, you can take that. However, I think that whether she was trying to cause a diversion or not, her behavior still made the officer nervous, and it added to his belief that there was a threat to safety.
Thank you very much.
And I just wanted to clarify if the court wants a 16L on the inspection issue.
If we want it, we will ask for it.
Okay, thank you, Your Honors.
Thank you very much.
Thank you.
Our next case is 2023-463, Commonwealth versus Hedquist. And my apologies if I mispronounce the name.
Good morning, Your Honors. I'm Karen Pickett. I represent the defendant, Celeste Hedquist, who last night I had to clarify that that is the pronunciation of her name, so you got it right. As Your Honors know, this is a relatively, or should have been a relatively simple case, in that there's an email from my client's email address to a Wellesley school committee member in December of 2017. That's at Exhibit 56 of my record appendix. As you know, this email followed up on an email sent by that committee member, Mr. Kelly, in which he discussed in a little bit of detail the fact that there were no trespassing orders against my client, but also her minor children. And in that email that he sent to the Hedquist, he CC'd the superintendent, Dr. Lucier, and mentioned that he had met with Dr. Lucier. They were talking about the terms of the no trespass order, et cetera.
So we've read the record. I mean, we know what the
Right.
email said.
Okay, so, and I won't bother reading the email. It's here in front of you. It's obviously, I would say, a little shocking. I certainly wouldn't want to get an email like this, and she swears at Mr. Kelly. But one thing I want to say is, as Your Honors know, the jury was instructed on both theories of harassment.
So you say the evidence has to be sufficient for both.
Has to
You
be
don't cite
sufficient
any
for both.
cases for that, and you might have heard the discussion in the first case we heard this morning about
Yes,
that.
Your
What's
Honor.
your view of what cases support that requirement?
So, and I apologize, I know the Commonwealth argued that there was sufficient evidence on the harassment, but I think probably the best case on that is Commonwealth versus Fragata, which basically says if you don't know which element or what theory the jury convicted on, and you can't, you look and you can't say there's no specific jury form or no specific instruction, then it has to be reversed, because it could be that the jury convicted on the harassment theory.
And that's Fragata?
Yes, I'm sorry, I think I have the case right here.
Even if just the spelling of the name would be fine. F-R-A-G-A-T-A?
Yes, it's 480 Mass 121.
Okay, thanks.
So the Commonwealth goes to great lengths, I think, because it has to show that there was sufficient evidence of harassment to argue that the email itself, which was sent to Mr. Kelly and CC'd to Dr. Lucier, made threats against the children, apparently, of Dr. Lucier. And I would suggest that a couple things. One is that the email mentions Matt several times. And again, the email doesn't threaten harm to Mr. Kelly's children, or obviously Mr. Lucier's children, but basically expresses frustration that if your children had to go through what my children had to go through, the bullying, being subjected to this no trespass order, maybe you'd learn something. So it's certainly hyperbole. Would I write it? No, of course, I probably wouldn't. But the case law is very clear, and the Commonwealth doesn't really make a big deal that these are public officials, and my client is responding to an email sent from a public official discussing a no trespass order issued by a government body. And so, as you see in my brief, I'm arguing that not only can the Commonwealth not meet the definition of harassment and has insufficient evidence, I believe that this email itself cannot serve as the basis of any conviction, even under the contact or no contact order, because in my opinion, based on the context and the fact that my client has an absolute First Amendment right to express political views, to respond to an email from a political official, that there's nothing in this email that should serve as the basis of a criminal conviction.
Well, the unprotected speech would be either true threat or fighting words, correct?
That's right.
So you're saying there's neither?
It's neither. And I don't think the Commonwealth argues that they're fighting words. Again,
in the context of the prior contact.
Again, I'll get to that point because, as you honors probably recognize from reading the record, this case devolved into sort of it was frankly insane. I've never really seen a case like it, but, and sort of the Commonwealth justifies all the evidence that came in, including evidence that, reading from an email where they're claiming that my client made anti-Semitic remarks. I mean, this has nothing to do with whether my client sent an email on this day and whether it was by accident because she was replying to the previous email. It should have been a really simple case, but instead the Commonwealth brought in all sorts of prior bad act evidence. And I understand that the judge said that her lawyer opened the door because, as you can see from the context of these emails, what they're discussing is this no trespass order that Dr. Lucier admitted ran against the children who had been in the Wellesley Public Schools. And so that's the context of it. And, you know, the fact that all these, and so the defense counsel opened the door to the issue surrounding the
Well, they opened the door to get to the issue. The context was in a prior communication, it was attributed to your client that she stated she would like some time to torture the children of Dr. Lucier.
Right, Your Honor, but that wasn't so what the defense counsel argued is that he went into the reason for the no trespass order. There's a lot of history between these people. He went into the reason for the no trespass order, which wasn't based on that. The no trespass order, I believe, preceded that conversation. In any event, he said, I'm going to explain why why she was upset because there's this no trespass order against her children. And and the defense counsel said that the no trespass order issued after my client approached a school principal's window and was yelling, bitch, bitch, something to that effect.
I believe it was you evil bitch.
You evil. I apologize, Your Honor. I don't know if I've ever said that in open court before. But again, I'm not trying to justify or say that any of these things were good or that any of us would do these things. But I do want the court to understand that there is something behind this. And in any event, and what I want to, it just keeps coming back to this, and this was a case cited by the Commonwealth, which is Virginia v. Black, a United States Supreme Court case. They have the obligation to show that there was a true threat. And the definition of a true threat, according to Virginia versus Black, is a true threat must communicate a serious expression of an intent to commit an act of unlawful violence to a particular individual or group of individuals. And I don't see how CCing Dr. Lucier on this email, directed specifically to Matt Kelly, who had sent the first email, can be viewed in that context. I'd like to just quickly cover the sort of the evidentiary issues and unless Your Honors have any questions about the sufficiency argument.
Yes, I think the question is, again, if someone was aware of emails or communications that she was indicating she may torture someone's children, and that person then got, in this context, was CC'd in email again, she's talking about doing something to someone, or the email is referring to doing something to someone's children. You're saying that doesn't constitute a true threat?
I don't believe so, Honor, in the context of, because she's not claiming that she's going to torture the children, and she's speaking directly to Matt Kelly. She uses his name several times. And again, it's she doesn't make any threats to the children. She says, we are going to do to your children what you have done to ours. Well, there's no claim that anyone in the Wellesley School Committee or any public official in Wellesley committed any violence against her children. Again, it's hyperbole. And then she says, when your children start to feel what ours have felt, then you will be a better person. Again, I don't think that can be construed as a true threat.
Can that be taken in the same context as the prior statement about, I want some time with your children so I can torture them?
I think if it was directed, perhaps if it was directed to Dr. Lucier, and but again, she's not being, again, that's a prior bad act that the defense sought to keep out, and I don't think by opening up the issue on the no trespass order, which was not based on that, that they then opened the door. I mean, at the beginning of the trial,
Don't you need at least some of the prior bad acts to set the context?
Well, I think that
for example, the surreptitiously driving in the dark, knocking on the window in the dark and saying what she said.
And the defense counsel, Your Honor, admitted that he had opened the door to that. So that's in the context. That's why Dr. Lucier testified that prompted him to get the no trespass order. So it's not as if, she's coming into court and there's not some information there. In fact, the defense counsel introduced that information. But how does that open up reading an email to her husband about people at a temple, and her, Dr. Lucier was allowed to testify to anti-Semitic remarks she made? None of that. I mean, that's just classic character assassination. None of that sets the context for this email. It has nothing to do with this email. And you'll see, Your Honors, if you look at the record, that all of these things were objected to. And it wasn't just once. I think there's at least 3 or 4 instances where these things are coming in that have absolutely no relevance to the case and certainly are prejudicial, as I argue in my brief. Finally, the admission of this evidence, and the judges, by the way, the defense counsel did object to the judge instructing the jury on the harassment issue, on the element harassment as opposed to the contact. And the judge said, well, I'm going to instruct on both. And he said to the defense counsel, but you can argue that all this stuff that they brought up isn't relevant to the case. Well, that's not really the standard. I mean, the standard is really the judge needs to decide at that point whether what had happened meets the legal definition of harassment in the context of First Amendment jurisprudence. But in any event, once the judge allowed the harassment instruction, the prosecutor got up and it was, it's an 11-page closing argument. This is a Dedham District Court trial. The prosecutor got up, and you'll see 90% of her closing argument wasn't about this email. It was about my client making anti-Semitic remarks. It was about that she wants retribution. I mean, the jury can read this email and understand the context from the no trespass order and the testimony that came in about that. But what they can't be, and by the way, that email, a supposed email about the temple, wasn't even admitted into evidence. So she's basically testifying herself, the prosecutor was, to something that wasn't even in evidence. And we know that the defense counsel objected a couple times.
The statement was introduced, wasn't it?
I'm sorry?
The statement was entered, wasn't it, about the temple?
The statement, she said to the husband, would you be surprised to know that your wife, just completely wrote this email? Just, improper, and these things were objected to. But then when they came in, they became the foundation for her closing argument, which, again, it's 11 pages, you can read it, and it should have been, as I said, and again, I know the defense counsel opened the door to some things, but it should have been a very simple trial because it's a paragraph email, and instead it devolved into sort of a character assassination of my client.
May I ask briefly about the denial of the defense attempt to impeach Lucier?
Yes.
So it was excluded on the basis that there was no evidence, or perhaps no good faith basis for asking whether he was aware of the criminal complaint that she had filed against him, or she had applied for, rather.
Right.
Because, well, there's no evidence of when he might have become aware of it. By when would he have to have been aware of it for it to have any significant impeachment value?
Well, so I believe she applied for this criminal complaint the day before the email.
Right.
And again, Your Honor, I believe that the defense counsel made a proffer that according to his client, Lucier did know about this. And obviously,
But by when would he have had to know about it in order for that knowledge to be of significant impeachment value?
So it would be
Any time
between-
prior to his testimony, or?
Oh, I think it would be any time prior to his report to the police at least, and that was like 5 days. So,
Is there evidence of when he reported it to the police?
I mean, again, it would be based on what my client told her counsel, which isn't in the record. But the counsel, I imagine, if, as any lawyer has to do, made a good faith basis that his client said that and I don't know how she knew.
Well, I guess my question is, can we determine from the record that this would have had any significant impeachment value?
Well, I think it would have. I mean, the other thing,
If
Your
we don't
Honor,
know
is-
when he complained to the police?
Understood, but the other issue, Your Honor, is this isn't, a situation where we're going to go down this, 2-hour path. It's a question that you ask a witness, which always happens when you don't have depositions in criminal cases. You don't know what the witness is going to say. So the defense counsel could say, were you aware that Mrs. Hedquist filed a criminal complaint on you December 13th, or whatever the date was? And if he said no, and the judge wanted to exclude any further information about the criminal complaint, fine, that's perfectly within his realm. But I believe that the defense counsel should have been allowed to explore that basic question, and then the follow-up would be, because Mr. Lucier testified she violated this order but didn't report it right away, well, maybe the jury would say, this really isn't a violation of the order. He must have thought it was an accident too, because it's a CC on a previous email.
Judge Smith.
The email in question to Mr. Kelly, the email that was the violation found at trial, is it your position that that was a reply-all email, that she composed an email and CC'd Dr. Lucier?
So if you look at, in fact, I always thought it was a reply, but I was looking more closely today. So there was an email, Mr. Kelly's email was sent on November 18th, 2017, and that's Exhibit 2 on page 55. And her email, Exhibit 3 on page 56, at the top line it says forwarded message. But it has the same Ray meeting follow-up. It has the same recipients, the same CC, but there were a couple people, not Mr. Lucier, Dr. Lucier, added to the to line. And so, sometimes when you're on your phone or whatever, you can hit forward or reply all or whatever. So I don't know the mechanics of it. Her lawyer did argue that this is, when you're on your phone, if somebody's already been CC'd, it's pretty easy to get them back in the loop, and that's why it was an accident. But obviously, that goes to the other issue, the contact issue.
Thank you.
Thank you, Your Honors.
Thank you very much. We will hear from the Commonwealth.
Good morning, Your Honors. May it please the Court. Michael McGee for the Norfolk District Attorney's Office. I'm going to start with the abuse of discretion claims that the defendant raises on appeal. The judge here was well within his discretion to allow Dr. Lucier to testify on redirect that the defendant had threatened him and wanted time with his wife and children to torture them. The judge was also well within his discretion on the cross-examination of Dr. Hedquist to allow the emails to the school employees which contained anti-Semitic remarks, as well as the incident involving Ms. Hedquist, the defendant.
How do you address the concern that, separate from whether or not the judge's individual evidentiary rulings were correct, in the end, this became a trial about her character, her universe of bad acts? I mean, if you look at the closing argument, there was so much focus the prosecutor placed on this background stuff and not on whether this particular email violated the order.
The thrust of the defendant's argument was that this was accidental contact. and that this had somehow happened in isolation. The defendant also raised that, and well, not really relevant, that this was somehow a overstepping by Dr. Lucier to even go forward with a harassment prevention order in the first place. What this showed and what the prosecutor argued was that this was absolutely intentional, that this was a pattern of conduct, and described the full picture for the jury, that this was not in isolation, that this was behavior that was consistent and was developing over a period of time, and culminated in this email that was not an accident, and was directed at Dr. Lucier, at least in part. The evidence about Dr. Lucier's prior email, it would have been well within the judge's discretion to allow that on direct examination of Dr. Lucier. This was part of the full picture here, that Dr. Lucier had been threatened, his family had been threatened, that the defendant had said to him, "I want your wife and children alone so that I can torture them." That was the impetus for the harassment prevention order in the first place, to explain to the jury, who's entitled to understand the full picture, that this forwarded email that CC'd Dr. Lucier then mentions, like your children are going to be feel the pain or feel, referring to children in that email could present a fear or harm or apprehension on behalf of the intended target here, Dr. Lucier, and that was an appropriate argument for the defendant to make. I mean, for the prosecutor to make.
Can we talk a little bit about sufficiency? Yes. First of all, do you agree that the evidence has to be sufficient on both theories?
I wasn't prepared on that particular argument or that case. It wasn't briefed, certainly, and wasn't cited. What I do see
the defendant arguing in a couple places in her brief that the evidence had to be sufficient on both or wasn't sufficient on one, so there needs to be, at a minimum, a new trial.
I'm not going to tangle on that particular point. I did just take a moment to take a look at those arguments in the brief. What I would suggest here is that there was an appropriate instruction. It was instructed on both theories, and the Commonwealth here had overwhelming evidence of both theories, both on harassment and on contact.
I might agree that the evidence on the violation of no contact is sufficient, but on the harassment, you need to show a true threat. Is that right?
Well, you need to show
that this email was a true threat.
You need to show that the victim is in fear of that has a reasonable apprehension or fear of based upon the threat that was made.
Well, just speaking doctrinally, the two kinds of speech alone that can constitute harassment are true threats and fighting words.
Correct.
Right? No one argues that these were fighting words.
Nope.
So if they're not true threats, then the harassment theory fails.
These are absolutely true threats.
Okay. So true threats are those statements where the speaker means to communicate a serious expression of an intent to commit an act of unlawful violence to a particular individual or group of individuals. What in this email communicated a threat of violence?
Your children will suffer?
We are going to do to your children what you have done to ours.
Correct.
Is there any allegation that anyone from the Wellesley School Department committed any physical violence against the Hedquist children? I don't see any. So saying we're going to do to your kids what you've done to ours does not necessarily equate to we're going to do violence to your kids.
Well, and that I think takes into the whole picture here is that prior to this, this defendant had directed an email to Dr. Lucier and said, I would like to get your wife and children into a room so that I can torture them.
Well, can you do that for purposes of determining what's a true threat? Can you take into account the context of previous communications, perhaps separated by some time, or do you have to focus on the actual words said and decide whether they alone constitute a serious expression of an intent to commit violence?
I believe so, and I think there was a lot more here, too.
Wait, when you say believe so, I was offering you an alternative, so can you take, what law says you can take into account the whole context of the party's relationship in deciding whether a particular bit of speech is a true threat?
This was a violation of a harassment prevention order.
Well, certainly there was sufficient evidence of violation of no contact, but we're focusing on what the harassment was, whether there was sufficient evidence for the harassment theory.
And what I would suggest to the court is there was sufficient evidence based upon the whole picture, and here you also not only had that initial threat, but you also had evidence that the defendant had driven her car with the lights off, parked in front of the school, and banged on the window of the, I believe it was the superintendent's office, actually it was the principal's office, yelling expletives at her. That taken as a whole, in addition to the incident at the basketball court and the anti-Semitic remarks, is that Dr. Lucier was well within his right to feel at fear for himself or for his family, and that this...
Well, that's not really the standard under true threats, is it?
The standard under harassment prevention order is that you have a reasonable apprehension of fear or for your safety.
We're not talking about a basis for issuance of the order. We're talking about whether this particular email was a true threat. And you're suggesting that taken in context, it is. But I'm trying to focus on where the threats of violence were. I mean, does banging on the principal's window at night and yelling, "You evil bitch," constitute a threat of violence to the superintendent or anyone who received this email?
Taken as a whole, I would suggest yes, and this court reviewed the constitutionality, not this court, the Supreme Judicial Court in Robichaux, dealt with the constitutionality of a protection order in Robichaux, and when it's a violation of an order, the court found that it is absolutely, that is not First Amendment protected speech.
How do you address the fact that any threat in the email was communicated against the children of the recipient of the email, not the CC?
I would suggest to the court that was a jury question, but what what came up just prior to this is this was a forwarded email. It was not a reply all. In addition, there were people added to the emails, and it was also the second email. There was an initial response to that to Matthew, to the school committee members' communication to Mrs. Hedquist that, in fact, stated, "Please don't include Mr. Lucier," and things of that nature. And then there was a pause, and then without another email from the school committee member, here's this forwarded email after Mrs. Hedquist did not get the result that she wanted, and now includes Dr. Lucier, who she knows has a harassment prevention order in place, and knows that she's not to contact him, and knows that the impetus for that harassment prevention order was the threat against the children, is now forwarding an email to him and mentioning children again. When your children start to feel what ours have felt, then you will be a better person. And all of the expletives and things of that nature.
Now, speaking of context, isn't the context that the superintendent is a public official relevant? Under the Bigelow case, I think it's Bigelow, the SJC drew a distinction between I think it was a select person and his wife, and found a lower standard for the wife, that you can't be sending harassing things to her, but in sort of lay terms, that if you're a public official, you have to put up with more than a private citizen does. How does that affect our analysis?
What I would suggest to the court is that the by virtue of being a public official or does not allow others to threaten the safety of you or your family. This particular, this defendant is not arguing that the harassment prevention order should not have been put forth in the first place. This is not a review of that. This is 9 months later, and this is a jury question about whether the defendant harassed or contacted.
Wasn't it a jury question in Bigelow as well, and the SJC said, no, it's not proper to go to the jury?
And I apologize, Your Honor, I'm not familiar with the Bigelow case, but what I would suggest under these facts and under this charge, this harassment prevention order, is that there was no motion to dismiss based upon the constitutionality of the charge. There was no seeking to vacate the harassment prevention order. She had well knowledge of it. She knew she was not to contact, the defendant knew she was not to contact the victim, public official or not, and that there was no contest at trial about that. That's not properly before the court in this case. Unless there are any other questions, I rest on my colleagues.
I do have one more. I'm not sure we got an answer to Justice Sachs' question. You said there's overwhelming evidence on both theories, the true threat and the contact. So you're conceding that there must be evidence of both to sustain the conviction?
I would suggest to the court that there was evidence of both. I'm not familiar with the Fergata case or whatever case counsel just cited.
Or Plunkett, for that matter.
Plunkett. I don't. Again, the jury was instructed on both. There was an objection to the harassment being given, but
that's the issue. It was a general verdict.
Right.
So the issue is it's unclear that unanimous on maybe contact, unanimous on maybe true threat, maybe 3-3 is district court, correct? So the question is, again, and you've answered a few times, you think the evidence was sufficient to both, but do we need to find the evidence was sufficient for both to affirm the verdict?
I can't think of a case offhand that says you have to find sufficient of both. They were instructed on or, as I understand it, and I believe under the facts and circumstances of the facts that were before the court, that they were more than sufficient, overwhelming of both theories.
Thank you very much. The case is submitted. We are going to take a brief mid-morning break. It is now just past 11:11, and we'll be gone 10 to 15 minutes.
Court, all rise.
Thank you for your patience. We are back on the record in Jones v. Johnson, 2023 P319.
Good morning, Your Honors. May it please the Court, Christopher Trundy for the appellant. I'm not going to go through, I realize I presented you with a whole number of issues on appeal, and I'm not going to dissect those for you this morning, unless there's an objection. I just want to say a couple of things just in response to the appellee's brief. One is that there is a claim suggested that the entire summary judgment opposition to the motion for summary judgment as it applied to the assault and battery case, or the intent was that my client intended to offer testimony as to the doctor's intent at the time. That is not the case. Our claim, as you can tell from the record, is that the course of conduct before, during, and after was sufficient in and of itself, including statements made by Dr. Johnson himself, for a jury to determine whether or not the damage to this woman's dental structure was intentional or not. So I think that that's an unfair characterization. It's an extreme in between the position of, oh, we're just going to go in and say I believe the plaintiff that this person intended to harm me, as opposed to the other end of the spectrum that the motion judge took, which is there's an expert report and therefore you have to deal with the expert report, and did not actually address the substantial evidence from which a jury could have found this. So I do not believe, or I would represent that at no time have we suggested, I don't think an expert can give that opinion of intent.
I didn't see the expert saying that. I didn't see your client saying it. That either of them was opining about what the defendant's intent was on June 20th.
I think you could read the expert's report as suggesting that. I don't think he comes out and says it specifically.
The judge didn't rely on it in any event.
Well, the judge ultimately says that she needed an expert to establish that she actually had a tooth. And I would suggest to you that he does not examine, for example, the statement by the doctor, by the dentist, that we just broke your tooth, which became in the record at the time the core, which I would suggest to you can be interchangeable terms, and then later the expert said, oh well, there was no tooth, it was just some resin material that was in the center of the tooth, which had previously had a root canal. I'm sorry, go ahead.
Well, finish up and then I have
Well,
a question.
what the motion judge suggested was that she needed an expert to say that the dentist snapped her tooth off. And first of all, I don't think any reasonable expert is going to say what actually happened and can give an opinion as to what actually happened. And I think that there are reasonable inferences in this record that that's exactly what happened. There's physical evidence to support it, and there's, of course, the conduct from the time she shows up and has a completely intact tooth that she wants to cap because of cosmetic reasons, and it's trimmed, and she's told there's good tooth structure. She goes back because it loosened, the temporary loosened, and then she goes in, and there's no discussion as to what is happening that day. There's no claim that this dentist gave her any running commentary as to what he found, other than that the tooth was broken and now you're going to have to consider an alternative financial arrangement. So I don't think it was fair, and I don't think there's any jurisprudence that says that in an intentional act case like this, that the rule that applies to medical negligence cases of expert opinion applies. And if that were to be the rule, it would be only fair to let litigants know that. I mean, there's no citation of authority that says this is an expert contest such as you have in a medical negligence case. And of course, it makes it very difficult in any case to get experts. And in a case where intent and what actually happened between the patient and the doctor, I think it's asking a lot.
May I ask, your brief at page 35 says that defendant took a photo shortly after the
Yes.
tooth snapped off or the core came loose or whatever, and you say it's in the record at page volume 1, page 592 in the lower right, but there's no photo at page 592, and I've looked at the other photos and I can't really discern anything in any of them. Is there a better version of that photo that he took at that time, so that if we were to request it, it would be worth our while?
I'm a little bit concerned about that myself because the court did issue a request for a better copy of a certain photo. And I believe that was an image that showed the broken root. Now, whether that was exactly the same one or not, I don't know. Let me just say that what we have in the record, I believe certainly would have come from the defendants, whether that was part of the original summary judgment package, or in the case of what was requested by the court by its order, was referring to evidence that was submitted at the trial in the matter. And the short answer is I do not have a better copy.
Okay.
Whether or not there was, I mean, you know, because of the...
That's fine.
Yeah. I mean, there may be a
You
better
don't.
copy from the other side. I don't know.
Just while we're on the battery claim.
Sure.
Your brief at 40 says that the dismissal of the battery count resulted in striking the claim of physical retaliation from the public accommodation count that went to trial.
That's correct.
I didn't see any record citations for that, and I don't know quite where to look for them.
Oh, it's Judge Kirpolani's decision specifically says that the plaintiff would not be allowed to pursue the battery claim or the damage to the tooth as part of the public accommodation claim. I don't think there's any dispute about that. He did go on to say that she could talk about her experience, which she says she was handled roughly, treated differently than she had been in prior visits with this dentist. That changed on the eve of trial with a motion in limine where the trial judge was persuaded that she should not even be able to tell the jury anything about the physical interaction between her and the dentist because that needed expert testimony. So the claim itself was excised, and it is in his rulings. That was part of that summary judgment. And he did carve out and said, yeah, but she can talk about this. Judge Wilson felt that would be inappropriate. And as a result, when the case gets tried with an instruction by the judge to the jury that no party is claiming that he ever did anything wrong as a dentist, that the dental care was okay. And I'm not here to ask you to visit that trial, I mean, because that stuff is all downstream of what I say are these de novo reviews for you. But that's why that decision relative to the battery claim was to excise all evidence of that. So that, of course, changes substantially the nature of that claim. I just want to say one thing about public accommodation in 93A. Now, we know, and there's very good reasons, why 93A should not be used in a medical negligence case, and the Supreme Court's been very clear about that. In this case, when it did go to trial, Judge Wilson took the position that you can sexually harass a patient and you cannot be liable as a public accommodation as long as you treat the patient. And the fact that he was willing to see her after the harassing behavior meant that the jury would have to find both that he sexually harassed her and
But, counsel, I mean, the issue isn't whether or not the treatment of the patient was proper. The issue is, can it be prosecuted in various boxes?
Well, so
help me understand
Yes.
how this is a 93A case in terms of unfair or deceptive practices?
Because what it is it becomes a condition of doing business with this doctor. So if you look at the Supreme Court case in Visas, I think it is, it says, this is the practice of medicine, that's different. The business side is where 93A, may have a foothold. This is not the practice of medicine. This is, in order to do business with me, you need to put up with sexually harassing behavior. And so, I mean, when you get into, for example, the discussion about the continuing violation doctrine, the defendant's claim is she knew she was being sexually harassed. She needed to go to the MCAD and cease treatment, which meant that she forfeited her right to complete the treatment, that she had started treatment with one doctor who everybody agrees is an excellent dentist. And so that, and of course, this is fee for service. This is a business. This is not her dealing with a hospital or something.
I see, as to the 93A claim, that the demand letter, which was attached to the complaint, described or alleged a number of effects on the financial relationship between the parties, not just the sexual harassment, not just the damage to the tooth, but you mentioned continuing violation doctrine, so I wanted to ask, Chapter 272, Section 98 refers to sex discrimination in admission to or treatment in any place of public accommodation. Do you read the term treatment there as limited to the medical treatment she gets in the office, or can any treatment in the office, such as sexual harassment or racial epithets or anything else, wouldn't that qualify as treatment as well?
That was certainly my argument at trial.
Okay, so and because the public accommodation law refers to many kinds of accommodations besides medical offices. So in that case, if she thought she was being sexually harassed, even prior to the last visit on June 20th, she had a ripe claim. She had all the elements, didn't she?
Well, she did, yes.
So then why would the continuing violation doctrine apply?
Because, well, two things. The continuing violation doctrine makes clear that we don't want to precipitate conflict on these things if there's a chance it'll resolve or discontinue. That's, one of the prongs. So she rebuffs his advances. It's well documented in the case. He responds like, okay, we'll keep it professional. At that point, she's entitled to accept his, I'm not going to do this anymore. And that becomes a jury question. Now, the reason I mention the 93A in this context is because you do have all of these statutory mechanisms which limit these claims. And you have, for example, Judge Wilson, who believes that, as long as you provide the services, you can't have a claim for sexual harassment or other abusive conduct. 93A, being a broad, remedial, equitable statute, generally heard by a judge, is there, as all equity claims are, to cut through when the law is insufficient to meet the claim. This is not your average public accommodation claim, as we all know. This is not one person going into a store and don't want to serve you because of who you are. This is a course of conduct over a series of months. So I suggest to you that there is no good argument for saying that 93A should not be available to remedy what went on here, particularly
part of the deception was part of the deception, unfair practice, was not charging her for certain procedures, correct? Is that your argument?
I'm sorry,
that he didn't charge her. There was no charge for certain procedures. Is that part of the theory of keeping her on the hook, for lack of a better word?
No, he charged her. There was one event where she went in for the temporary cap became loose. She went in and he said, I'm not going to charge you for this visit. You're going to buy me a drink when I'm in New Bedford. So that was an attempted quid pro quo that leads to this various, the evidence of all of these text messages and so forth.
I understand. I thought that was part of your argument of how it was unfair, deceptive under 93A.
No, I think it's unfair and deceptive because it basically you pay a bunch of money, and then you have to put up with this, or you walk away. I'm virtually out of time. Unless there's any other questions, I'll...
Why isn't the right box, or perhaps the most appropriate box to put this in, the civil rights claim in count 1, and you make no arguments about that on appeal?
There is an appeals court case that says that you must pursue the public accommodation case ahead of the civil rights case, and that's why. There is a case on that is at the appellate court level. It's not a trial court case, and we did look at that. Now, it does have some language that suggests that possibly if pre-trial that particular accommodation case had gone out the window, that you might be able to default to that. But again, those two matters are both statutory, which is why I think 93A, in many respects, cures a lot of the statutory limitations that attach to the unique set of circumstances in this relationship.
Thank you very much.
Thank you.
We'll hear from Dr. Johnson's attorney.
Good afternoon. My name is Randall Weeks. I represent Dr. Ryan S. Johnson, the appellee. Obviously, the record before this court at the motion to dismiss stage and the summary judgment stage is much different than the record at the trial. I mean, some of the allegations here are obviously horrific, but the trial record is much, much different. I would start by saying this is a challenging response to an appeal because there was nary any case law cited, so it was hard to distinguish cases that were relied on by the plaintiff.
Could we start with a 93A?
I would like to, actually.
Yeah. So why weren't the allegations in the demand letter about the that was incorporated in the First Amendment complaint, alleging that after the defendant broke the plaintiff's tooth, he retained the money for the Crown while saying that the Crown procedure probably wouldn't work, and then suggested she proceed with an implant costing $8,500, and then pressured her to return for more treatment after falsely stating she would lose all her money and that he had obtained her insurance payments or coverage.
Yes, Your Honor. I think that the crux of the 93A demand was that he was claiming a per se violation of 93A by virtue of a violation of the Massachusetts Privacy Act. And by
the judge disposed of those. He's not arguing those on appeal. He's arguing that the requirement that there be some involvement of the entrepreneurial or business aspects of the medical practice be there before there can be a 93A, and he's saying that he alleged that.
Well,
She.
I don't believe he actually alleged that on appeal, Your Honor, but I will say that, as you know, the DeViris case is the one that says it's got to be an entrepreneurial or business aspect of the business, and in fact that it has to be done with the intent of getting financial gain. And I don't believe the opposition to the motion for summary judgment, the way it was pleaded in his amended complaint, and it wasn't argued at all. The argument focused, it didn't get at all into the financial gain aspect. His argument didn't get into the entrepreneurial or business aspect, but rather got into whether or not it violated a particular regulation that was cited, and the regulation pertains solely to infirmaries and nursing homes.
So the 93A claim was disposed of on the motion to dismiss, and in the opposition, plaintiff's opposition that you included in the addendum to your brief, it quotes at length from the 93A demand letter, including 2 paragraphs of allegations about the financial impact or implications of the interaction between the parties. So on a motion to dismiss, where we're reading the allegations in the light most favorable to the plaintiff, why isn't that enough?
I did not read that, Your Honor, as it looking for to get financial gain. There was a failed dental procedure, and that was what the cost to be would to when the resin core failed. That's what the cost to be to cure that. So in addition, there was a number of, so I was also say that the plaintiff cited to Bourne and H&R Block in support of his 93A motion, neither of which were argued at the motion to dismiss stage. The Bourne case was
The judge didn't dispose of the claim on the ground that there could not be both a 93A claim and a public
correct.
accommodation claim. So the Bourne issue is not really in the
Ms.
case.
Wu, Your Honor. I just wanted to make sure that we dealt with that. With regard to the battery, Your Honor, there was an expert that was hired by Dr. Johnson, and he looked at both the pre and the post photographs, x-rays of the tooth, and was able to discern that the tooth was never broken at the gum line as alleged by the plaintiff. Rather, it was if anyone has had a root canal, they drill out the nerves and they put in a resin core and then they put a crown on top of that. The resin core that had been there since 2006 had become loose and no longer viable to support a crown.
So Dr. Johnson is a bit of an expert too, isn't he?
And he testified as such in his affidavit, Your Honor.
I mean, I'm talking about Dr. Johnson, not Dr. Della Russo.
Yes, Your Honor.
Okay, so when he allegedly says your tooth snapped off at the gum line, that seems to be in conflict with what Della Russo later says, that it was just the core coming loose. Why doesn't that create a jury issue?
Well, as far as a genuine issue of fact, we have Dr. Johnson in his affidavit stating, we have Dr. Johnson's tech that was in the room during the entire procedure, and we have Dr. Della Russo all stating and submitting photographic and medical evidence stating that the tooth was never snapped before the gum line. And in addition,
But we have Dr. Johnson himself making what one might describe as an excited utterance before he had time to think of another story.
Or an admission.
but that was certainly her position, but based on the medical, unrefuted medical evidence, the court found that they couldn't create a genuine issue of material fact. And that evidence also included affidavit of the plaintiff where she said, this was deposition testimony, and she was asked that prior to the breaking off of her tooth, the procedure where she alleged her tooth was broken off, it had been shaped down. This is all part of the deposition testimony submitted for summary judgment. It had been shaped down to support the new permanent crown. And she testified it had appeared as if it were gone. It was freaky looking, she said. So it's not only Dr. Della Russo.
I thought she said that she had a rabbit tooth there, a small tooth that she could see.
Well, it's all collective. You're right, Your Honor.
And then after whether it was the tooth snapped or the resin came loose, she looked, the defendant gave her a mirror to look in her mouth, and she said there was no tooth there.
Well, Dr. Della Russo, who looked at both the pre and the post medical x-rays, stated that it was the difference before and after was not a snapped off tooth, it was the core. I mean,
so a jury, even if Dr. Johnson admitted that at the time of the procedure he had said your tooth snapped off at the gum line, the jury would be compelled to find by the expert's testimony that no, there was no damage to the tooth, it was all resin coming loose.
The jury heard that, Your Honor. I mean, she was allowed to testify as to what Dr. Johnson said with regard to the count that was remaining, and she did testify to that.
Well, I'm not asking what the jury did in the limited claim that went to trial. I'm asking for summary judgment purposes. Is Dr. Johnson's own statement at the time entitled to no weight?
I don't believe that her allegation as to what Dr. Johnson said compared to Dr. Johnson's affidavit and an affidavit of an expert who looked at medical records that were not refuted, and I will add...
Why isn't that the weighing of evidence, which is not what you're supposed to do on summary judgment?
It's lay testimony versus expert testimony.
No, but Dr. Johnson's testimony could be considered not lay.
What I think I hear the court saying is that if you believe her saying that Dr. Johnson said that fact is enough to create a genuine issue as to a full medical record, including before and after photos, and I don't believe that that's sufficient to create an issue of fact. I mean, I think she had the opportunity from the time Dr. Johnson's report was given to her to depose the expert. I see in the appeal here, they're trying to limit it or exclude it or somehow have the court look at it differently than, they never tried to limit it at any point in the proceedings. They never hired their own expert. As a matter of fact, she testified.
But why isn't this analogous to a surgeon who is heard, I'm not sure how the patient heard him, but is heard saying, damn, I should have sutured that artery before I closed up the body. And you have experts saying, no, that wasn't the problem.
I mean, I don't think that without expert testimony, and that was what the motion court also ruled, that is sufficient to create a genuine issue of material fact. I mean, it's a self-serving statement, Your Honor. I mean, you know, it's a self-serving, and that also is...
Don't we have to accept it as true, that he said that?
The case law on self-serving statements, I think, is, I don't believe that to be the case, Your Honor. But no matter, that was what was before the summary judgment court, and they looked at not only, and as the motion judge went into in great detail, it wasn't just the expert reports, it was also her own statements admitting as such that there was barely any structure, like actual tooth structure, not the composite resin core that was actually there.
Can we talk about the intentional infliction claim?
Certainly.
So the judge determined as a matter of law that this alleged conduct wasn't extreme and outrageous. I'm not seeing how that determination can be made as a matter of law.
Your Honor, I'm very truthfully, I don't necessarily agree with that either. The judge also said that she thought that under Iannaccino that he relied on conclusion. It was just poorly pled or pleaded. And I thought that was the other reason that the motion judge gave for that.
So, I mean, the other reason being that he didn't intend to inflict whatever emotional distress occurred, and that it was just a byproduct?
There was several reasons given by the motion judge as to why that she thought it should be dismissed. And the first that you gave, I'd be disingenuous if I told you I agreed with you on that. I do believe that if you read the pleadings, the plaintiff on their amended complaint just listed the 4 requisites of intentional infliction of emotional distress. I would also suggest to Your Honor that if you, based on the development of the record after the motion to dismiss, where it was determined that the tooth was not snapped, but rather it was the core that gave way, that this was a harmless error, Your Honor, at this level.
So,
because the only act that would give rise to the egregious, I mean, we know that this is a high bar.
So, in other words, we'd have to agree with you about the battery in order to uphold the dismissal of the intentional infliction claim.
Or disregarding the plaintiff's expert report.
Okay. So
Defendant's brother.
The second basis for dismissing the intentional infliction claim was that there wasn't an adequate allegation that the defendant intended to inflict whatever emotional distress there was, that any emotional distress that ensued was merely a predictable result of his actions aimed at doing other things, whether it was to bring about a relationship or something else, or retaliate against her for rejecting his advances. Am I accurately characterizing what the judge said?
That's exactly what you said.
Okay. So the judge, a few paragraphs before then, correctly quotes the first element of intentional infliction as saying that the actor intended to inflict emotional distress or knew or should have known that emotional distress was the likely result of his conduct. So when the judge herself says, oh, well, all he's alleging here is that the emotional distress was the predictable result of his actions aimed at other ends, isn't that a conclusion that, in fact, she satisfied that element of emotional stress?
I'm not going to disagree with that, Your Honor. Was there, I'm getting low, were there questions on the continuing violation doctrine? Or, I mean, certainly under the continuing violation doctrine, the third requirement in Cuddier is that she demonstrates, or the third requirement in the Cuddier is that if she knew during the limitations period that she was being harassed, or a reasonable person, she knew or should have known under the reasonable person standard, and it was unlikely to cease. And then in the record, you can see a number of incidents that occurred from the first visit within the limitations period, including the first visit where he talked about one of his techs having breast surgery, where he talked about the dating scene where she lived, where he talked about other inappropriate and sexual innuendos or comments. And she said, yes, after that, I was scared, my hair was falling out, I had stress, I had anxiety, I couldn't sleep. And then she had a subsequent visit in February, and she said, I perceived that his hand grazed my breast. And then he talked about getting together, and she said she had even worse stress and was...
I mean, there's plenty there for her to think she was being sexually harassed. What Mr. Trundy says is that after he texted her back and said, okay, we'll keep it strictly professional, she was in essence entitled to rely on that and assume that there would be no further harassment.
Well, the testimony in the record and from her deposition was that she said she believed she'd been sexually harassed, and she also stated that she was worrying all the time about going back to him, and it started to consume her. And there was a visit where she brought her aunt because she was afraid as to what might happen. So it's clear that that this is an admission by her, in addition to the physical manifestations of the sexual harassment, that she didn't think this was going to end, and that was quite clear for the record.
She didn't think it would end, or was concerned it might not end?
She was bringing her aunt because she was afraid to go to a...
No, I understand, but isn't that a subtle distinction that is potentially...
What would the standard be, Your Honor, to say that it wasn't reasonably, the person didn't reasonably think it was going to cease? I mean, there's nothing more profound or absolute than she's consumed by this. She's worrying about going back. She's so terrified, according to her, that she's actually bringing relatives to a visit, or subsequent visits. So, I think it couldn't be any clearer that she didn't think that it was going to stop.
I'm afraid your time is up.
It is.
We have no further questions, so the case is submitted.
Thank you, Your Honor.
Thank you very much. Our next case is 2023 P796 Woodland LLC versus the Horace A. Kimble and S. Ella Kimble Foundation and others.
Good morning, Your Honor. Good afternoon, Your Honors. Brian Hughes on behalf of the Plaintiff Appellant Woodland LLC. May it please the Court, back in 1929, the Millis Building Association conveyed something less than the entirety of the fee in a series of roadways in Millis, Massachusetts, without reserving anything to itself. Pursuant to the derelict fee statute, as it is now being interpreted.
Okay, before you launch into that, let me just ask you, usually in a case like this, we have visual aids that are provided in the record appendix. Obviously, they have to be submitted below. And, especially in a case like this, where you're dealing with roads and easements and subdivisions, I take it there's nothing in the record that helps us understand what your initial claims were in terms of where the lots owned by your client were in the subdivision, where the paper streets are, where the streets have been built into public roads, and so forth?
There are 3 plans in the summary judgment record which are part of the appendix.
There are plans, but they're not that helpful in terms of identifying who owns what, which streets have been built on, which haven't, et cetera.
Well, the final exhibit in the summary judgment record, I don't have the appendix citation in front of me, is a sketch or a plan drawn up by my client's engineer, and it does show which roads are unbuilt and which are private and which are public.
Does it show which properties your client owns?
No, it does not. My client owns substantial amounts, but our argument has less to do with his properties than it does, his properties, and it does have to do with the ways.
Okay, but tell us if we're wrong in reading it this way, but your initial claim was that your client had acquired a 2/3 undivided interest, I believe, in the entire paper streets. Is that a fair?
Yes, that was the initial claim.
Okay, and the claim you seem to be focused on appeal is that your clients own to the center line of the street, of the paper streets, adjacent to the properties that they actually own. Is that?
Yes, that is exactly what we're asking, that's what we're arguing here on appeal.
Okay, and what, in practical terms, is the difference between those? Because we have no idea what lots your client owns compared to the paper streets and so forth.
What it would do, if your honors, for example, agree with my argument, what would happen is that the derelict fee statute would apply, and my client would own up to the center line or the entire width of the roads it abuts on. However that shakes out. If my original argument was successful, and I can explain why there's this sea change, my client would have owned 2/3 of all the roads that have not been adopted as public ways in the entire subdivision. That argument is based upon the idea that it appeared that the Millis Building Association separated the ways almost as if it were separate lots.
Okay, now, help us understand how the new theory you have was before the judge in the land court.
It wasn't. The new theory basically came out because the Conway versus Caragliano case came out while this appeal was pending.
And what entitles you to take the benefit of that case where the argument was never made in the land court?
Well, one issue that was before the land court was how does the derelict fee statute apply to this 1/3 interest? That piece of law still has not necessarily been developed. So we're here before you asking for the Conway principle that you don't look beyond the four corners of the deed to apply to even partial grants and ways without reservation. The land court didn't have the benefit of that ruling, but if this went to the land court at that time, a land court judge, Judge Spicer, might not feel that he would have the judicial authority to extend that rule on his own without guidance from this court. So we're asking that this court provide that guidance to the land court and remand it.
The argument was never made to him, correct?
No, it was not capable of being made because the sea change in the law that happened 2 months after appeal.
Why couldn't you have made the same argument that ultimately succeeded in Conway?
Because
I mean, it's not as if this is some announcement of a new constitutional principle of under the Fourth Amendment by the Supreme Court.
Well, I would say it was somewhat an announcement of a new principle in the sense that the Conway case said you don't look beyond the four corners of the document. A lot of cases have touched upon that theme, but ultimately those courts have actually looked beyond that.
But the statute always meant what the Conway court says it means now.
Yeah, but it wasn't applied that way, that's what I'm saying. So the land court would feel constrained, I believe, under the Cubic case and the other cases are similar, where they did look or open themselves up to looking beyond that to beyond the four corners of the deed. And here we have a grant of a partial fee in the way. It's not I don't know if there's going to be another case like this before this court ever, and how that applies based upon.
Probably not, but I'm just.
Yeah, it's a unique case, and there's language in the deeds that below we felt that we could not ignore, and because the statute's never been applied to ignore words in the deed. So we had a choice. Go forth and argue that we ignored the words in the deed, or applied all the words in the deed to have as much effect as possible, and that was the tact we took. It wasn't because of, we wanted to take some advantage of the language. We just felt as if that you had to apply all the words of the deed, otherwise the land court would say, well, what about these words?
Okay, let's say, just completely hypothetically, you were to eventually get a declaration that your client owns to the midpoint where it has property abutting the paper street and the entire thing where your client owns on both sides of the paper street. What does that get your client? Why isn't the real fight here, if any, about easement rights in the paper street and not about the somewhat technical issue of who owns the underlying fee?
Well, it's because the land would not be developable at all if they don't own it. if we don't own the entire fee, it's just going to sit there, frankly, forever, because the Millis Building Association's been dissolved for almost 100 years. As to easements, there are two ways that such an order would actually still help. First off, easement rights are contained within the people who live in the subdivision. It's a finite pool. My client could theoretically go door to door and try to obtain waivers of those rights. But also, easements can be moved. Some of these easements may have been extinguished. Dealing with an easement is another step, and the land court discussed this, and it's another step in the road, but we can't discuss easements until we know who owns the actual land, who owns the fee. And like I said, my client can't even obtain a mortgage to develop a portion of this land if someone else owns, or possibly dozens of others, own a third of the fee in the way. That's just an obstruction. My client can't do anything with that at that point. Easements can be worked with.
Assuming hypothetically that we were to affirm the judgment, would you be free to bring another action based on the Conway theory, seeking different relief, more limited relief? Is there a claim preclusion problem, or maybe even an issue preclusion problem? I'm not sure.
I do not believe so. I believe that because the land court didn't make any findings or conclusions relative to the 1/3 partial fractional grants in the way, the land court kind of skipped over that piece of history and went straight to the subsequent deeds, saying that the derelict fee statute applied to those parcels. In theory, there's a question of law outstanding that might be able to be raised again, asking the court for interpretation of how the statute applies to the 1/3 grants. And at that point, I don't know the parties I'd have to join, because in theory, the Millis Building Association's shareholders, heirs, and heirs of heirs are the opposite parties. And it's also somewhat seeking an advisory opinion from the land court at that point. So there might be some procedural hurdles, but since that particular issue as to how the statute applies to the partial grants was never decided. That's one of the reasons why we appealed, because we specifically requested that relief, and the court effectively denied it, but just by not treating it.
Okay, but related to Judge Sachs's question, I'm looking at the judgment itself, and in the paragraph on declaratory relief, it says, on count 1 of the Second Amendment seeking declaratory judgment, that the petitioner, Woodland, does not own an undivided 2/3 interest in the way shown on the plan, and that Woodland does not own any undivided fee in the said ways in common with the respondents. Why is that inconsistent with your new theory of the case? Did the judge, in fact, rule against you on this? Is this adverse?
I would say the judge never interpreted the 1929 deeds as to say what my client owns. It was never declared. What the judge said was that he doesn't, I haven't established that we own 2/3 by way of these deeds, and that because of that.
Because you had a particular theory you asked him to address, and he addressed it.
Well, he addressed it in the point to the point where I believe, I don't know what the motivation was, but by deciding that the other parties weren't jointly owning this land with my client, he lost subject matter jurisdiction, and he limited his decision based upon that narrow area, when frankly the real issue was, how do we deal with this partial grants of the fee? That was ultimately the issue.
Now, why not pursue a Rule 60B motion instead of an appeal?
Well,
given where you're not arguing the judge did anything wrong, you're arguing that he should take into account the Conway case, which came down after.
Well, I filed a Rule 60B motion requesting the further findings relative to how we deal with a 1/3 fee, but that was still before Conway. This case was already docketed when the Conway case came out. I actually had to get an extension on the brief in order to basically change my entire brief based upon that case. The judge has not had the opportunity to interpret Conway relative to this case. But like I said earlier, if the judge might feel constrained in saying, well, I can't extend this principle, so I'm asking this court to extend that principle to cover, and frankly, it would close the hole that Conway left, because Conway dealt with a right-of-way. the grant of a right-of-way without a reservation of the fee. Here we have an actual grant of a fee. It's kind of a whole different world if you look at it that way. It's not just a right to pass, it's a right to own, a right to possess.
Is there anything in the judge's decision that makes you think he would disagree with your assertion of the Conway theory, knowing or at least appreciating your argument that that might leave this land completely undevelopable because the owners can't be located?
Yeah, I mean, I believe that my primary, if I was in the other side's shoes, which I don't have another side, I would argue that judicial restraint requires that the court stick with just Conway's facts. It's a right-of-way grant. There's never been a case touching upon the grant of fee in the way. The judge would be, frankly, perfectly within his rights to say, I'm just going by the four corners of Conway.
Would we be in a better position to rule on how Conway applies if we had a land court judge who can take evidence and find facts, take a first crack at it?
Well, I would say that the facts are actually sufficient in the record to answer. It's a title question. There's no testimony. There's no any evidence of intent. There's no one left who would be able to provide evidence. It's just the title at the registry of deeds that the judge had before him, and he did not make any rulings relative to how the statute applies to that fractional interest.
So,
No, I was just going to say, it would be an unusual case where an appellate court reversed what the trial court judge did based on a theory that was never argued.
Well, wouldn't necessarily be a reversal or an affirmance. It'd be a remand for, a declaration of what Conway's principle means relative to fees, that it is broader than just grants of rights of way, and that remanded for further proceedings consistent with that opinion. And, Your Honor, I see that my time has expired.
Has not expired yet.
Oh, well, 1 minute.
So earlier you referred to there being a sketch prepared by your client or on behalf of your client.
Yes.
Is that the legacy engineering sketch that was the last exhibit to your complaint?
Yes.
Okay. There's no date on it.
It hasn't been stamped. I can
All right. Well,
supplement that.
We'll see if we need that, we could ask for it. But it also doesn't really identify who owns which lot. So we would have to trace through all of the deeds to determine that.
If Your Honors would make the request, I can provide a supplement just showing what my client's record title owns. I mean, this case involves people who, the other parties were ones who don't even actually own the land there anymore. They owned their great-grandfather owned the land. So it never really had to get broken down as to who owns what parcels, because we were just looking for a declaration as to what this language means. I can supplement and provide the court with, a clear letter showing who owns which parcel.
Only submit something if we request it, and it sounds like that information is not in the current record, in which case it would not be appropriate for us to look at. So do not expect us to ask for it.
I won't.
Thank you very much, counsel. The case is submitted.
Thank you, Your Honors.
Our next case is hybrid, and what that means, among other things, is we're going to exit for just as long as it takes to get all the parties on the line.
All right, please.
Microphone check. Can you hear us?
Can you hear me?
Yes.
Good afternoon, counsel. Can you hear me?
I can. Can you hear me?
Yes, thank you.
I see my, oh, there we go.
Thanks very much. We are back on the record in a DCF matter, 2023 P 752. It is a hybrid argument. We're beginning first, I believe, with Mr. Robin.
Thank you. Good afternoon, Your Honors. My name is Jeremy Robin. I represent the mother appellant in this case. I want to begin with something I think upon which we can all agree, which is mental illness is stigmatized in our society. It's often minimized, and those who suffer from it, such as my client in this case, are often marginalized. Here, the mother's mental health illness were at center stage. They were the centerpiece of the case. We can also agree that the mother suffered from these significant disorders her entire life. And as the findings indicate, she didn't hide behind them. She volunteered her mental health afflictions, her depression, her bipolar, her schizophrenia, serious stuff, significant mental health afflictions. Yet in spite of these significant mental health afflictions, she showed ability to parent her children, who were 9 at the time of trial, her twins, subject of this case. Approximately the first 4 years of their lives, she had custody of them. And importantly, the DCF took temporary emergency custody on 3 occasions. And on 3 separate occasions, the trial court returned custody to the mother, suggesting strongly that, in fact, the trial court shared my opinion that she showed promise to parent these children. It seems to me, in reading the findings, there are really 3 bases upon which the court seeks to take this most extreme measure of terminating a parent's rights, which we can, I believe, agree is an extreme measure. The first is the domestic violence allegations. But the mother did seek and obtain a restraining order when she needed to. And the DCF, in fact, had coordinated joint visits with the mother and father, again suggesting strongly that they did not see DV as a concern. It would seem to me if that were a concern, they would have separate visits with both parents. Regarding, the second issue is regarding mother's ability to parent the children with special needs. Well, she moved from Tennessee to Massachusetts for the very reason of securing the needed health care for them. She took them to medical appointments and the like. She was aware and could identify what autism meant with respect to one of her children.
Counsel, isn't there robust evidence that the children were not thriving under her care?
I don't believe there was. I guess you'd have to break that down for me when you say robust evidence. She had the symptoms of a person with significant mental health illness, for sure, and that would mean services were required. She needed services. She was crying out for services. So was she an average parent who could function autonomously? I don't think so. She needed services.
I'm focusing on the children, that the children were the furthest thing from thriving.
The standard is not where the children are thriving, I believe, to terminate parental rights. The standard is, or one of the standards is there a reasonable chance that the mother could parent at some time in the future? We're not challenging current parental unfitness. We're just saying that the mother has shown a parental ability such that termination was inappropriate or premature, however we want to call it. On 3 separate occasions, as I say, the trial court agreed in principle with that theory, returning custody. And the bar here, I believe, is higher for the DCF to terminate versus the removal standard. So were the children thriving under her care? No, I don't think so. Was she struggling at times? Yes. But was she making effort? Was she engaged in services? Yes. Was she trying to do the level best that she could to parent these twin children, one of whom had special needs? I think the answers to those questions is yes.
I mean, isn't it clear they both have special needs, one to a greater extent?
Yes. And again, that's the challenge of parenting children in their position, but I think she was making a lot of efforts. She was aware of what it meant. She didn't deny what it meant. She did take them to medical appointments, treatments, and the like, had visits. Were there patches of time when she wasn't able to see them? Yes, that's in the record. But again, I think that's a function, and I don't mean to overstate this, but I don't think it can be overstated. This is a person with significant afflictions, and that's the sadness of this, is that she had these afflictions and she was still doing her best and trying the best with the ability that she had. Was it enough to get over the bar of showing a reasonable possibility that she could parent in the future? I think the answer to that's yes. So, if there are no further questions. So.
There was one domestic violence in 2017, correct?
That sounds right, yes.
And it was a serious allegation in front of the children. The father allegedly was banging her head off the table, I believe. And it was one issue, but the court was concerned that the mother wasn't taking that issue seriously or wasn't as concerned as a court would have preferred, and also concerned about the fathers, their continuing involvement. Did you want to address that further?
I believe that was the occasion when she did secure a 209A restraining order, though. So I think that action certainly sounds to me as if she's taking it seriously enough to go to court to swear out an affidavit to get the protection she felt she needed. I think that shows some seriousness of the allegation.
I think her testimony was she only went to get one after they advised her to. Is that correct?
I think
well, that's all right. The record will stand. The other question, on the physical abuse of the children, it was alleged some serious physical abuse at a 51A. There was an unknown reporter that alleged the mother struck the children numerous times. It's unclear to me. The court credited some of those allegations. We don't have the transcript from that initial hearing, so it's unclear to me what weight the judge gave to those allegations. The judge didn't credit her response to the allegations, but did you want to?
Yeah, let me address that, but I want to kind of merge that into the fact that I think some of those allegations were on the table at the time of the removal hearings. I think you're referencing 2016, 2017 timeframe, and the trial judge didn't credit that enough such that she chose to return custody. So I think the court was aware of it, the DCF was aware of it, not to minimize the allegations, but I don't think it was substantiated enough at that point. So then it would beg the question, how could it be substantiated enough at this point at the trial level? So, thank you.
Thank you, counsel. We will turn to Attorney Driscoll-Weiss.
Thank you, Your Honors. May it please the court, Roberta Driscoll-Weiss. I'm here today. Ooh, there's two of me. I'm here today on behalf of the appellant father. I would like to begin by thanking the court for your flexibility in allowing me to argue remotely today. In my brief, I adopted mother's arguments, and I would adopt also what my brother has said here today. I think the interesting, if I could, I'd like to go back to Your Honor's question about whether the children were in fact thriving in mother's care. And I think this is one of the interesting things about this case. In April of 2016, when DCF initially filed the first 51A and filed the care and protection, the allegations reflected concerns about physical abuse in the sense of the way mom disciplined the children, failure to take the children to medical appointments, and DCF removed the children, placed them in separate placements, and at the temporary custody hearing, the trial judge returned the children to the parents' care. So presumably, although she doesn't spell out in her findings why she did that, presumably it was because she did not find that the department's allegations rose to the level of reasonable cause to believe that the children were suffering from serious abuse or neglect or were in immediate danger of abuse and neglect such that removal was warranted. That would be the standard under 119 Section 24. DCF again sought custody a month or so later, alleging that the family was now homeless. And again, the judge returned custody to the parents, again, presumably because she did not find that the allegations rose to the standard of 119 Section 24. And this happens again in August of 2016, in January of 2017. It was not until March of 2017 when there was this single episode of domestic violence, which father acknowledged in his way, that the trial judge finally said yes and granted temporary custody to DCF. So if you look at the record as a whole, whether or not the children were thriving, at least according to the trial judge, the issues of the manner in which mother disciplined the children, the manner in which mother took the children to medical appointments, the manner in which mother, their living situation and their financial situation, none of that for a year, none of that was sufficient to warrant a finding that the children were at risk of immediate abuse or neglect. And so that one can only extrapolate from that the incident that sort of pushed it over the top for the judge, so to speak, was this single episode of domestic violence. And immediately upon the incident occurring, father left the home. There's no evidence that he ever returned to the home. As my brother stated, mother and father were given visitation with the children together. So it raises some question about how significant the department's concerns were. So as I argued in my brief, this is the facts that the judge that were not sufficient for the judge to warrant removing the children are the same facts that she later on relies in her findings to terminate the parents' rights. And, my argument on father's behalf is that it's an inadequate, there was an inadequate support for the termination of the parents' rights. The incident of domestic violence, I was hard pressed to find another case in the Commonwealth where termination of parental rights was grounded in a single episode of domestic violence. Certainly, there's plenty of case law to reflect that termination might be appropriate when when the abused party refuses to leave the abuser. There's lots of case law to support that, or when there are denials of the existence of domestic violence. But there's not a single case in Massachusetts that predicates termination of parental rights on a single episode of domestic violence. And I think that's what the judge did here. I think it was that episode of domestic violence, not the other issues that she had been sort of tolerating all along and not finding met the level of abuse or neglect, of imminent risk of abuse or neglect. It was that one episode of domestic violence that really tipped the scales for her, and I think that
May I ask a question?
Absolutely. I apologize, so I can't see you.
Quite all right. It's Judge Sachs.
Thank you.
You argue that the judge can't base a finding of unfitness on these allegations that were previously found insufficient to give temporary custody to DCF, the 2016-2017. But the parents both stipulated to unfitness in September of 2018. How do we deal with that?
My argument, Your Honor, and if I wasn't clear, I apologize, is if these instances were not adequate evidence of inappropriate parenting to warrant the trial judge giving custody to DCF over the course of many attempts over a year, then they aren't adequate to support to be the foundation to terminate the parents' rights. Yes, both parents stipulated to unfitness, but from there, the question is it necessary to terminate their parental rights? And my argument is that the evidence just was not there, that they were unfit to the degree that one should be in order for the court to take that, what we all recognize is the extreme step of terminating the parents' rights.
So do you contest unfitness, or do you only contest whether termination was an abuse of discretion?
I contest that termination was an abuse of discretion, Your Honor, because I think at the time of trial.
But not unfitness. That's what I'm trying to get at.
No, father stipulated to his unfitness, and it's reflected in my brief. He would not be seeking custody of the children today. His position is that they should be with mother because mother is capable of caring for them.
Now, I'm a little confused by your argument that about the past proceedings here, where, surely you're not arguing that the judge was stopped from reconsidering the past evidence of unfitness, and isn't it just as plausible an explanation that the judge was bending over backwards to try to make sure the parents had every chance, and then as time went on, and then with the advent of the domestic violence incident, it was just a bridge too far, and everything came streaming back in?
No, I'm not arguing that the trial judge was stopped from considering those earlier instances. What she fails to do, though, in her findings is to explain or support why, when each of these findings collectively, and by the fourth time DCF sought temporary custody of the children before the episode of domestic violence, she had heard the same allegations over and over and over again. It's not clear to me, and so I'm not sure if it was clear to her, that how is it that the same facts that are not adequate to grant temporary custody of children to the department under a lesser standard are the same facts that warrant termination of parental rights under a much more stringent standard. And that's where the judge doesn't say in her findings, I bent over backwards to try to keep custody with the parents. In fact, I think it was, at least it was somewhat clear to me from her findings that I think she didn't believe that this was adequate, or at least from the trial record up to the time of trial, that this wasn't an adequate basis for granting custody to DCF. She consistently and repeatedly left the children with the parents. And so the only difference in that final bid for custody by DCF was this episode of domestic violence. And again, if that was
Counsel, I think we get it. And you can't see the red light, but it's been blinking for over a couple minutes.
I apologize, I did not see it.
No apologies necessary. Thank you very much.
much.
We will hear from first Mr. Cuddle, I believe.
Good afternoon, Your Honors. Can you hear me okay?
Yes.
I'm going to be splitting my time 8-7 with the children's attorney. Judge Milkey, could you let me know if I'm running over, if I have a minute to go?
I'll let you know when the yellow light comes up.
Your Honor, as the department brief states, we're asking this court to affirm the decree. The trial judge in this case made actually 403 findings, 30 some odd conclusions. I want to bring your attention to one of the conclusions, or part of a conclusion. It's conclusion 26, where the court concluded that the evidence demonstrates that mother and father have an enduring inability to parent the children. And that's the entire case. As you're well aware, the children have profound special needs in this case. The department agrees with your view of the temporary custody hearings. Judge Milkey, this judge clearly was trying to assist the parents. The temporary orders that were issued by the court are well within Section 24 of the statute. They were conditions, and the conditions were that the department was going to provide services to the parents. One of the services that the department tried to provide for the parents was a parent aid, which mother and father did not want to have. There was clear evidence that the children were not eating, they had failure to thrive. This was a 5-year trial. This wasn't a case that can just look at the temporary custody portion of the matter. Judge Sachs, you're correct. The mother and father stipulated to their unfitness, and clearly what happened in this case, whether they were unable to or chose not to, they weren't able to address their mental health issues, which were seen by the court through their behaviors, their inappropriate, hostile behaviors with the children at visits and also with staff. And the department tried to give the parents a parenting mentor up to 2018. The parents refused to work with those mentors to the point where the service was canceled.
Is there a sufficient nexus between the mental health issues and fitness?
Yes, Your Honor, there is, and it's throughout all the conclusions. In conclusion 26, the judge makes a general statement that the parents, I think, uses the word conditions. There's a nexus between the parents' conditions and harm to the children. The nexus is that the mother and father, regardless of what diagnosis they were given, and there were several throughout the case, their behavior and how it was manifested in their visits with their children, how they worked with the department staff and others, they clearly were not able to, they were not stable, unfortunately. They did not present themselves as stable parents.
So is it something specifically attributable to the mental health issues that either of the parents was found to have, or is it really just the conduct and what you point to as the enduring inability to parent? In other words, does it matter whether it's connected to mental health issues?
Well, this connected.
Or is there something specifically attributable?
You mean like if it's like a particular mental, like a bipolar disorder and some type of condition, or?
Well, I'm asking whether the deficiencies that were found need to be specifically attributed to mental health issues in order to affirm the judgment as you're asking.
Well, they don't have to be specifically related to a particular diagnosis. They have to be related to the ability or lack thereof of the parent to parent their children with their mental health issues, and clearly that wasn't happening. And one of the arguments I just want to clear up for the panel that the mother and father both make, this isn't a single domestic violence case. This isn't just a single mental health case or a single housing case or a single case about parents not having the capacity to care for the children. It's all of those factors. And the court made that clear in their conclusions of law. All these factors contributed to mother and father's unfitness and their future unfitness.
I was bothered by the reliance on domestic violence. There was one incident 5.5 years before the judge issued her notice of decision. Maybe the parents didn't do as much as they possibly could have to get counseling, take courses about domestic violence. I mean, they did some, but that's one incident 5.5 years before the judge made her decision. Is that really a weighty factor for us, particularly where they aren't living together?
Well, we're not sure if they're not living together, Your Honor. The court wasn't certain about that.
Well, I didn't see the court expressing uncertainty. I saw that he picks up his mail at her apartment, right, and occasionally they talk about co-parenting, or maybe even once a month. But
there was evidence in the case, to answer your question. There was evidence in the case, and the court found that mother and father especially around the time of the temporary custody hearings, both admitted to other domestic violence between them prior to the children.
Yeah, much earlier.
Right, and mother had a
Yeah,
long-standing...
2013, and she had a restraining order against her former husband for a period of 7 or 8 years. Isn't that exactly what we want a domestic violence victim to do? Get a restraining order. There's no evidence that it was ever violated or that she attempted to reconcile with him or that she hadn't dealt with that issue entirely appropriately. I don't understand why that gets held against the mother.
I don't think that the court held it against the mother, Your Honor. I think, as the court found in her findings and conclusions, what she was concerned about and what she needed to be concerned about is, did mother and father both adequately address that issue with the treatment that was offered to them so that it would minimize any possibility of that happening again?
Well, isn't the best evidence of whether they adequately addressed it the fact that there was no incident in 5.5 years?
There was no reported incident, Your Honor. There was nothing in the record, so I'm not going to say there was. But I don't think that the issue is that straightforward. The court has to also consider how mother and father addressed the issue. Mother couldn't testify at trial about her earlier domestic violence with her former husband. She had a visceral response to it, and the court took from that she hadn't been working on that issue. There's no information in the record after 2019 that mother participated in domestic violence classes. She had done it up until that point, and there wasn't. Father refused to talk about domestic violence.
I just want to interject. The yellow light has come on. You still have some time left. I did not want to interrupt your flow with Judge Sachs, but please proceed.
Well, thank you. Just in wrapping things up, the department's brief sets out all our arguments and really focuses on the court considering all the factors, all the parent shortcomings, not just one single factor, and finding that they are incapable of caring for these special needs children and that the parental rights should be terminated. Thank you.
One quick question about housing stability. The mother had an apartment in Charlestown since October of 2019.
Yes.
That seems pretty stable.
The court acknowledged that, but the court wasn't bound to not be concerned about the past history of mothers and fathers' unstable housing or lack thereof from the beginning of the case.
Is there reason to think she's going to lose that?
Not that I'm aware of, and I don't think the court. I think the court was concerned that if she was going to have the children back, she may not have a plan in place. If that was a single issue, Your Honor, and all the other evidence of unfitness wasn't here in this case, there might be more of a plausible argument, but that's not the case here. It's just one of many issues.
Thank you very much, Mr. Cuddle. We will hear from Attorney Donovan.
Good afternoon. May it please the court, Alessandra Donovan for the two children here. When I was preparing for this argument, I started thinking, when you're on an airplane and they come on and say if there is a decrease in pressure or something's happening and the oxygen mask come down, you put it on you first, and then when you're settled, you help your children. This is kind of what did not happen here. The parents had some severe shortcomings, some of them not of their own making, the mental health and the physical health issues. They did not take care of them. Because they did not do that, then they could not take care or even understand what the issues of the children were. I mean, these children have, they're not just special needs. There's a lot of stuff. They have medical issues. They have Dilantin syndrome, global development issues. They're autistic. They have speech and expression issues. They have ADHD. They have a panoply of services in place in school, after school, doctors, etc. And these parents, and especially mother, just refuse to even see these issues. At the visits, she was offered to have training to deal with the behavioral issues that Jay, the child who's at the Home for Little Heroes, and she said she didn't want to do it because she didn't see any progress, whereas it's documented that because of the stability and the structure and the services that were in place, that the child was indeed making progress. But also, I wanted to bring up the fact, I just wanted to put it into context. So, and I'm looking at my notes because I want to get the dates correct. It's been almost 7 years since the children were removed, and there were 4 years between when the parents stipulated to unfitness and the trial. And then, of course, we know that the trial went on for 3 years. And at this point, the children have been, one at the program for 4.5 years, and the other one with a foster family, the same foster mother for 4.5 years.
So just to be clear on that, there's been no change of status in terms of...
There hasn't, and it's not been a hurried process. The parents had plenty of time, and they knew, especially during the trial, they knew what they had to do. They just did not do it. Now, did they not do it because they didn't want to? Addressing your question of, is this just a personality or behavior thing? Or didn't they not do it because their untreated medical and mental health issues prevented them from doing that? They kind of were walking through molasses, as I like to say, and they couldn't address what they needed to do. The issue about the children being returned twice, as someone pointed out, they were returned with conditions. And again, like the rest of the trial, it's an accumulation of factors. So when the third time at the 72, the judge decided not to return the children and give temporary custody to DCF, and still the parents did not, I mean, that should have been a come to Jesus moment. This is it, right? They still kept behaving the same way. They still had the same issues. And there are plenty of examples, but one stood out that when mother was told not to use, by the judge, not to use physical discipline to discipline the children, and she said she was only not doing it because the judge told her. Another example was that she said if the children were returned to her, she would not have them in services. She did not believe in Western medicine. She would not comply with any of that. And those are the very services that enable the children to make the progress that they've made.
We saw the references to conditionally returned, but I didn't see cites to the record where we could figure out what those conditions were. Do you know where we can find those?
I don't think I do, Your Honor. I could provide it.
We'll let you know if we need that.
Thank you. I don't want to ruffle to my notes here. I don't think I have it. The lack of understanding, again, I don't know if it's just behavior or the other issues that they have, that father wants the children to be with mother after it's been enumerated during trial, all the mother is not able to parent these children. And yet father is happy to have the children returned to mother. And by the same token, talking about the DV, we don't know if there have not been other incidents of DV. The parents were conflicting in their responses about the episodes of domestic violence. It was only like in bits and pieces that things came out, and sometimes they contradicted each other. And so for mother to say that she's going to rely on father, for financially, and it seems like they are together, that's kind of the typical being with the abuser and being beholden financially to the abuser. So to me, those two examples kind of symbolize the not understanding the issues. And as my brother pointed out, it's a constellation of factors that made the judge come to the conclusion that she did. The mental health being a primary one that was not addressed, and there was a nexus, and then she went through detailed findings on why the mental health impacted the case, her way of parenting. the domestic violence, you don't need a nexus. It's in itself, it shouldn't be. And as in one case says, you don't have to wait for the next bad thing to happen to address domestic violence. And I see that my time is almost up, and I would ask this court to affirm the lower court decision.
I see the minors are identical twins. Do you believe the judge expressed enough concern or showed enough judgment or discretion on placing them apart as opposed to placing them together?
They have similar issues, but also Jay in particular is more challenged than his brother, and is not making the same progress that his brother is making, although he is. He was not walking almost not walking when he was first placed where he is at, and now he is. And there's some other examples, but yes, they cannot be together, but the foster mother of L has made a great commitment to both of them. So, for example, she was a resource teacher in a resource.
Is this all in the record?
It is. I believe it is in the record. She has said that she was willing to have them be together, and I know that they are together. They had a first overnight last week.
That's not in the record. That's not in the record.
It's not on the record.
Okay.
But there is that commitment that, and there are visits together and all of that. So definitely.
Thank you.
Thank you all very much. The case is submitted. These cases are always challenging, at least on the facts, and I applaud not only all of your excellent hard work, but the sensitivity you've all shown in this difficult matter. Thank you all. We are adjourned, and our thanks